All the last only 3 days is there. Okay, give.
I'm grateful to your Lordship.
The defendants are directed to pay US dollar of rupees 4,28,500 along with the interest at the rate of 18% per annum from 1st June 2015 till realization of the decretal amount within 60 days.
Grateful, my lord.
CS is disposed of, decree be done.
Grateful. Deeply obliged.
You will get the judgment tomorrow because some corrections.
Very well, my lord. Grateful. My lord,
Yes.
my witness is there, my lord, for cross-examination.
Milord, I start today, but Milord, I am not fully ready. So I will start. And for Milord, kindly.
Let you start. Let's see how far you can go.
Milord. Please.
I am Pradeep Kumar Mukherjee.
Kindly tell my lord, how are you connected with the plaintiffs?
I am a consultant to the plaintiff.
Since when you are acting as a consultant of the plaintiffs?
Since 2018, February 2018.
Are you retainer of the plaintiffs? Retainer.
I work as a consultant only.
Kindly tell my lord, on what basis you are working as a consultant regarding payment of consideration?
I work under a contract basis. I work on a contract basis. I work for 6 days a month. And if anything is further required, I work online. Online.
So for 6 days in a month,
Yes.
you are working as a contract basis, on contract basis. What remuneration are you getting from the plaintiffs?
And I am objecting to this. It's no way connected with the suit or his remuneration and salary. I am objecting. My lord, kindly record.
Why? What is the objection for?
It's no way, my lord, perhaps related to the suit.
Maybe he's taking the benefit of
Very
that.
well, my lord. Kindly record my objection. That's all. Subject to objection.
Subject to objection. Question within bracket subject to objection.
Yes.
Presently, I get around 58,000 per month. 58,000.
58,000 per month.
Yes.
Mr. Mukherjee, on the first day of your deposition, recorded on 13th December 2022, you were shown a copy of soil report. A copy of soil report annexed in the judge's brief of document at pages 291 to 334. Being subsoil exploration work for the construction of bridge number 182. What did you find in the said report?
The said report provides the geotechnical formation of the riverbed, of the soil below the riverbed.
Let the report be shown.
Yes.
From that report, we will see the answer to.
Kindly have a look at this report.
Yes,
Kindly tell my lord, who has prepared this report?
this report is prepared by one company called Vision Lab. Vision Lab,
Vision Lab.
right? VISION.
Mr. Mukherjee, after perusing the report, do you find any fault in the report?
Fault as such is that the narrative of the soil mentioned there does not really match with the existing soil.
In other words, should I take it that according to you, the report is not perfect?
I agree.
Should I take it that you are taking exceptions to this report?
Yes, because prior to the award of the contract, the tender did not have any geotechnical report with it. Therefore, whatever was understood from the BOQ items that formed the basis of the offer for the contract. Now, when the actual soil report was done, when the actual soil report was received, we found that it varied from what was envisaged through the narrative of the BOQ item.
Is it not, should I not take it that before challenging the exception, before taking the exception of any report, you should give a chance to the person who has prepared this report?
Actually, I cannot follow your question. Please.
I mean to say, whenever a report is challenged before the court of law, that is the kind of exceptions to the report. So, is it not necessary to hear the person who has prepared this report?
You see, the basic perception of the soil was that the soil under the riverbed comes under the category of all kinds of soil, which is clay, sand, and silt. Now, with that perception, the contractor made an offer. Now, it has to be kept in mind that the contract had a provision for a separate soil exploration work under Schedule A of the BOQ. Now, given that option, one is inclined to believe that even if there is an error in the narration of the BOQ item, there is a scope to go for a actual soil exploration work for the contractor himself and check the actual geotechnical profile under the riverbed. This was the understanding from the contract. It was not ever made known before the contract was awarded that another soil exploration work is being conducted by the employer himself, and that became apparent only 1 month after the award of the contract. So, whatever was provided in that soil report had to be accepted by the contractor because it is an item rate contract, and the employer had the option to not implement the work under Schedule A.
Mr. Mukherjee, I refer tender notice dated 23rd February 2010 in respect of construction of bridge in question. Would you please say that the terms and conditions of the tender, there was no provision for the inspection of the site of the construction of bridge before submitting the tender?
Yes, there is a provision to inspect the site, but these include the other commercial provisions, such as the location of the site, the surroundings of the site, the climatic conditions, the labor conditions, the availability of transport, access to the site, banking facilities. These are the conditions which are normally seen there. It is not at all possible for any contractor to see the site and take a view of the bed under the river. That is beyond question.
As such, you agree that in tender document, the condition is provided that the tenderer should make verification of the site before submitting the tenders for construction of bridge.
No, the condition does not say such things. The condition says that you have to visit the site and get acclimatized. You have to visit the site of work and get acclimatized the conditions thereof, the temperature, the rainfall, the surroundings, the labor conditions, the availability of resources like aggregate, sand, etc., the availability of like sand, aggregate, and the other residential availability, the access, the nearest station, the nearest police station, the nearest bank, the nearest market, so that based on all these data, one can finalize his rates. Nobody is expected to the rates. Nobody is expected the contractor is not expected to speculate a geotechnical report what remains below the bed of the river.
Is it not the duty of the tenderers to be satisfied regarding the location of the location of this site or the soil conditions of the soils before submitting their tender?
Not at all. Because once you have a provision in a contract to go for a soil exploration work itself, once you have a provision to go for the soil exploration itself through a BAQ item, I don't see any reason why a contractor should bother about what lies below the bed of the river. About what lies below the bed of the river.
According to you, the tenderers submitting tenders taking a risk in that, taking a risk of the soil condition of the site for constructing the bridge in question.
I could not understand your point again, please.
I say that according to you, that the in tender, the condition is provided that the contractors would verify the site before submitting its tender for construction of the bridge. But if it is not done by the contractor is not taking risk and so একটা কোয়েশ্চেনটা একটা পড়ে দিন তো প্লিজ। না এইটাই পড়ে দিন। Yes, what is your answer?
There is no question of taking a risk. When you work for a design-based contract, the design has to be based on pure mathematics. The mathematical calculation has to be based on pure technical data. There is no question of any speculation. So there is no question of the risk you are trying to justify.
In that event, it is whose duty to prepare the report of the soil at the site?
The employer's duty 100%.
My lord, I want some time to prepare myself.
Then it will go long date.
Fix
Commercial-
tomorrow, my lord. The
Fix
next day
tomorrow
fix
also?
tomorrow. Further.
Come tomorrow. This tomorrow also it is fixed because commercial matter it will be disposed of as early as possible.
So instead of tomorrow, my lord, it's very
Sir, after 16th February, it is fixed to, it was fixed on March, 23rd March, then 23rd March, the matter is fixed today.
my lord.
You will not get ready.
28, my lord, matter was fixed last 28, my lord. And since the court did not sit on 28, therefore the matter has been fixed today, my lord. So, my lord, actually, I had several matters prepared, hearing matter, my lord. So, therefore, I could not.
But this
made
is a
ready
commercial matter also. This is a commercial matter. It has to be disposed of as early as possible, as per the guidelines of the act
Give
itself.
me one opportunity, my lord. I will be ready, my
The
lord.
only thing, my lord, the date was fixed on 1st of May
Yes,
in presence of the parties. My lord, that is the only thing, my lord, I want to say. Nothing more.
1st of May.
1st of May, 2nd of May, my
2nd
lord
of-
said 1st of May. My lord, the matter got listed, my lord, automatically on 2nd of May because my lord was having a circuit bench on 20th.
Correct.
So, my lord, let it be there tomorrow, my lord. Let us proceed at least 2-3 questions, my
My
lord.
lord, tomorrow, my lord, I have 5-6 matter for hearing today itself,
Okay.
and all hearing matters. And therefore, my lord,
So before
I-
fixing,
you
also,
spare time,
this
my lord.
court-
I-
before fixing, you could have been informed this court on the last date when the matter was fixed.
I was not in town, my lord. And before that, I mentioned the matter before your lordship. I said I may not be in town. Your lordship said when we call, you send your junior and it will be fixed. So kindly give me an opportunity. my lord.
Okay, please get it done. Establish. Counsel for the respective parties are present. Plaintiff witness. Cross-examination of plaintiff witness resumed today. Counsel for the defendant submits that he is not ready totally to continue with the cross-examination and accordingly prays for time. Counsel for the plaintiff submit the matter is already fixed tomorrow for further cross-examination. But the counsel for the defendant submit that he is some personal difficulties and is not in position to cross-examine the witness tomorrow and prays for fixing another date. Considering the submission made by the counsel for the respective parties as a matter of for the interest of justice and as a matter of last chance, let the matter appear on
And kindly fix it for 2 days, my lord, because presence of all. No, it's a commercial matter. It will be anyway called on, my lord.
20 and 21st June. 20th June and 21st June.
Lord.
Two date I am giving you.
Yes, my lord. I will
Complete
make
your
my-
process.
myself ready on that date. Grateful, Lord.
That has been allowed. The receivers shall immediately within a period of 4 weeks receive the total share consideration of of the sale of 40 kathas of land from the above mentioned two purchasers, 20 kathas each at the rate of 20 lakhs each kathas, and to keep the sale consideration amount in a short-term fixed deposit yielding highest return with the State Bank of India.
State Bank of India বলছে তো?
State Bank of India High Court branch.
Millard, may I indicate, Millard, my learned advocate on record was appointed by Justice Sain Millard way back in
United Bank of
2014.
India.
There is a Millard already passbook, Millard,
United Bank of
yes, United Bank of India. Only thing, Millard, he can be replaced by Mr. Banerjee. He can be released formally and Millard replaced by Mr. Banerjee.
United Bank of India High Court branch.
And Millard, he may be directed to inform the bank, and bank may be directed to change the operations of the bank in his name because it is being done by him. Millard, this is a passbook. I have called for the passbook.
No, already going on. You're not. Because of the last order, Justice Sen has directed Mr. Banerjee.
No. It was Justice Kapoor has, but but bank operation was his name because he was not being discharged formally.
Okay.
Millard, so Millard has to discharge him formally, Mr. Divanath De, and Millard, he has to be replaced by Mr. Rohit Banerjee.
As per the order, already Rohit is.
Yes, but no formal discharge. Millard will find that there is no formal discharge.
Okay. Name of the trust. On receipt of the total sale considered, the trustee shall execute the deed of the conveyance in favor of the purchasers, two purchasers, and within 4 weeks thereafter. So 4 weeks, 8 weeks. The registering authority shall assess the stamp duty on the consideration amount, but not on the market value. All the costs and charges of the expenses shall borne by the purchasers. The receiver shall file comprehensive report before this court within 10 weeks. So, Mr. What is your good name?
Mr. Divanath De. And Millard, the bank may be directed to change the operations in the name of Mr. Rohit Banerjee and act on the copy of this order.
Bank account number?
Bank account number, Millard.
Or you give the copy, provide the copy to my court
But I am
office,
giving the passbook itself. I will collect later on.
because the number will be provided.
The overleap, Millard, the number is mentioned.
Thank you. So J is disposed of.
Is disposed of. Only Millard, Millard will also direct that the money may be disbursed to the school or the trustees after this.
Let he complete, then you come to
Yes.
the court, then the court will decide how much amount is required and whatever it is.
Obliged.
My lord, I am appearing for the defendants, my lord. My lord, on last Friday, my lord, we have been instructed to appear in this matter, my lord. My lord, so I'm seeking for some time, my lord. We are
Appearing for?
appearing for defendants, my lord.
I am
Change
for
of
the
advocates,
plaintiff.
my lord.
Plaintiff, my lord.
Hmm.
Today, my lord, your lordship, our last occasion extended time for completion of the commission work, my lord.
Hmm.
On 28/4/2023, the matter was fixed for cross-examination, my lord. But due to illness of the witness, my lord, the examination could not be held, my lord.
Hmm.
So your lordship, I am praying for extension of my lord, because they have handed over a letter, my lord, email, my lord. Kindly see, my lord. And my lord, this is the last minutes of meeting, my lord. My lord. We almost, my lord, completed our cross-examination, my lord.
Cross-examination of plaintiff witness.
Plenty. For crossing the defendant witness, my lord.
Cross-examination of defendant witness.
Grateful, my lord. I'm led by Mr. Satoru Banerjee, my lord.
Counsel for the respective parties are present. You are for the
I'm
Plaintiff.
plaintiff, my lord.
counsel for the plaintiff submitted. The cross-examination of the defendant witness is going on. On the last date fix.
28/4.
On the last date fix, the counsel for the defendant witness could not appear due to ill health, and due to which cross-examination could not be completed.
My lord.
Counsel for the plaintiff prays for extension of time for examination, cross-examination of the defendant witness and commission.
My lord, I could not follow, my lord.
Cross-examination of defendant, witness and commission. Extension of time for cross-examination.
My lord, extension.
In view of the submission made by the counsel for the plaintiff, time to file commissioner report is extended till 30th June 2023.
My lord, first week of July possible, my lord, because some 2 weeks is there holidays, my lord. That's all.
By 5th July to
Grateful, my lord. Grateful,
by 5th July 2023.
grateful, my lord.
My lord, three is for my lord. An order was passed on 12th of April, my lord, for correction of the order. I have made necessary corrections over here. If your lordship kindly checks, my lord, I was added as a member. I was added as a party to the suit as well as made a member of the interim board of the company. Pursuant, my lord, the inference is being drawn from my father, who was, my lord, the chairman member of the interim board. As per the original order of, my lord, consent decree was passed in 89 and 92. Your lordship has mentioned that. So, my lord, I am drawing my inference from there only. Maya Devi Ojha, it was, my lord, written wrongly in that order that Maya Devi Ojha was my mother, but she is my aunt, whose, my lord, legal heirs are not being represented.
That's why I wanted to see your application.
Yes, my lord, application, my lord, I think
But that has not, record has not come.
my lord, my lord, my application is there. If your lordship kindly sees, my lord, I have marked it. Your lordship kindly pardons me for that.
Defendant number 2.
My lord, I have been added.
Defendant number 2, Pramod Rai Ojha.
No, there are two petitioners, my lord. I am the petitioner number 1. Petitioner number 2 is the son of Pramod Rai Ojha.
The present suit, the father of the petitioner number 2 was the defendant number 2.
Yes,
So
yes,
defendant number 2 is the Pramod Rai Ojha.
yes,
Correct.
yes,
And the father of the petitioner number 1 was the member.
yes. Because, my lord, in the order, my lord, it's being reflected that Maya Devi Ojha was my mother, but that was not so. Maya Devi Ojha was the wife of Gunwant Rai Ojha, and their clans is not being represented.
Where you default? Where you mention, sir? That is the problem.
Your lordship,
That is the problem. You have not mentioned clearly here.
my lord, in the petition, I have mentioned that I am the son of Chimanlal Ojha. Your lordship kindly sees. I am drawing my inference from Chimanlal Ojha.
See, this petition was filed by 2 petitioners.
Yes.
Correct. One is
Pramod Rai Ojha's son, that
What
is
is the
Bhaskar Ojha, defendant number 2. My lord, my father was not made a party in the suit. Petitioner number 2 is the son of Chimanlal Ojha, who, my lord, was the chairman member of the board in the original order of 89 and 92, the consent decree.
Then the order is to be recalled. It cannot be corrected. The total page is to be, it is to be recalled, sir. If file a recalling application, how it can be corrected, the total 3 pages? Huh?
That cannot be corrected, my lord.
How it can be corrected?
My lord, my addition
You
was
correct.
as per the inference of my father.
You
Well,
correct.
it is
Kindly come your cost title first.
My lord.
The humble petition of Anup Hoja, Bhaskar Hoja. Who are they?
My lord, Bhaskar Oja was the son of
Where-
defendant
where-
number 2.
Let me show from the
But my
application.
father was not made a party to the suit.
Show me in the
My lord.
application the Bhaskar Hoja is the son of so and so, so and so. Okay, where is that? You have not made any application, any description in the application. You made a review application, we'll see to that.
Very good.
You have not described anything. In the humble petition of Bhaskar Hoja, humble petition of Anup Hoja. And you have total given the details of the earlier proceedings. How you have
No, my lord, in the order
That is what,
passed
my
by
lord,
your
Mr.
lordship.
That is what my lord Mr. Mitra had affected on the first.
No.
Yes, my
Kindly
lord.
do not try to
After
mislead
that,
the- mislead
later
the-
on, he did not proceed. with
Very
that.
well, my lord, I'll come up with a recalling
with the recall
with a
application. Whatever.
clarification application. I'll
Yes,
come.
next.
Your Lordship, this is my
That is corrected,
application.
no?
Yes, Your Lordship. After that, Your Lordship, there was a mistake on my part. Instead of correction in the prayer D, the correction actually that was required was in prayer C, my Lord.
Hmm.
If Your Lordship kindly takes up the Your Lordship's last order dated 8th May 2023, therein Your Lordship had said that it is pointed out that in prayer D of the master summons, Your Lordship, that will be prayer C. And instead of letter I, it will be letter A.
But you mentioned letter I.
Yes, Your Lordship, it is
You have
my
mentioned
mistake.
letter I
Yes,
in
Your
the
Lordship, it is
application.
my mistake. I could not appraise Your Lordship properly.
This has been not corrected. Let's see. It was not corrected. Okay. The matter is listed to be mentioned for correction of the order dated 8 May 2023. Full stop. The counsel for the petitioner submits that in the order dated 8 May 2023, in third paragraph, third line, the prayer D within bracket small d is to be read as within bracket C. And in the same paragraph, same line, the letter capital I is to be read as letter capital A. Similarly, in paragraph 4, first line, the letter I should be read as letter A. And in paragraph 4, line number 3, the prayer D is to be read as prayer C. And letter I is to be read as letter A. In view of the submission made by the counsel for the petitioner, in paragraph 3, line number 3, in order dated 8 May 2023, instead of prayer D, it should be read as prayer C, comma, instead of letter I, it should be letter A. And in paragraph 4, line number 1, instead of letter I, it should be read as letter A. And in paragraph 4, line number 3, the prayer D shall be read as prayer C, and letter I shall be read as letter A.
Also, Your Lordship, in the last line, in view of the submission made by the counsel of the petitioner, leave is granted to correct prayer D. That will be prayer C.
In
my
the 5th paragraph of the said order, the prayer D should be read as prayer C. This order may be incorporated with the order dated 12th April 2023 and 8th May 2023.
Grateful, Your Lordship.
It was corrected yesterday. Hmm. Next. Which one? Item number 5. Nobody is appearing. Go in the monthly list. Next.
Lordship, I'm on behalf of the plaintiff number 3. Lordship, it's for the correction of the order dated April 10, 2023. Order copy to nahi hai hamare kache. ওর মধ্যে থাকবে।
What is to be corrected if you are not having the order copy?
Lordship, in the third line or last line of the order, it has been recorded as the prayer A of the master summons is allowed. Lordship, the same should be notice of motion since we have filed the notice of motion.
Where is the order? You not bring the order. Bring order tomorrow. Come with the order tomorrow.
Lordship, can let it be pass over? I'll bring the order.
It's on record. What is on record? Come tomorrow.
In terms of your lordship's order, we carried out the amendment, my lord, and an amended copy of the petition, my lord, has been served upon them, my lord.
My lord, we would like to file an affidavit in opposition to the amended application which has been served on us. Kindly, my lord, since court reopens on the 5th of June, kindly grant us time till the 15th of June.
Amended application.
Yes, it has been served on us.
My lord, this side of vacation, they may.
This side of vacation only 2 days. How it is
So for
possible?
affidavit in opposition is concerned,
I don't
they may
think
allow.
counsel for the respective parties are present. Full stop. You are for the petitioner.
I am for this petition.
Counsel for the petitioner has filed amended petition in terms of the order passed by this court dated and amended petition. Full stop. Counsel for the respondent prays for time to file affidavit in opposition to the amended application. Full stop. Let affidavit in opposition be filed within 2 weeks.
My lord, I was saying 2 weeks after reopening.
2 weeks after reopening of
My lord,
the
it would
court
be
from summer
a
vacation.
longer than, my lord, including these days and another week after the vacations, it's all right, my lord. We have been
Within 2
suffering.
weeks after summer vacation, comma, a reply if any be within a week, within a week thereafter. Let the matter appear on 27 June.
Very grateful. I'm grateful to you.
But my application under chapter 13A and their application for demurrer, we had completed our arguments, my lord. Ms. Manju Manat was appearing on there. She had commenced her arguments, but thereafter, my lord, matter has been adjourned on one pretext or the other.
No. Thereafter, after hearing, it was fixed on 17th at 3 p.m. The court was not.
No, I'm sorry, my lord. It was fixed on 17th April 2023 at 3 p.m. I believe the court's business did not permit the matter to be taken up.
So other side is not here.
It's appearing in the list.
My lord, then in that event, kindly fixes a date, my lord.
So Malay was supposed to argue.
Without their demurrer application can be dismissed, my lord, but I should not ask for that.
It is to be mentioned.
Yes, sir, I should not ask for that.
Counsel for the, you are for the defendant.
No.
I'm for the plaintiff. Plaintiff petitioner. My chapter 13A is pending. I've made
Counsel
submissions.
for the plaintiff is present. Then appears for the defendant. Full stop. The matter was listed on
17th April 2023.
17th April 2023 at 3 p.m. But the matter could not be taken up for hearing. Accordingly, counsel for the plaintiff prays for fixing the matter on a specific date and time. In view of the submission made by the counsel for the plaintiff, let the matter appear on
Any day at 2, my lord, if your lordship's diary permits, my lord.
19 July.
This is the greatest pre-vacation gift I could have got. July.
Because all the matters,
But 3 p.m. at least.
I don't think so.
One slot.
12 p.m.
Anything.
This is an old matter, my lord.
No, the
And
other
chapter
side-
30 and
other side
chapter,
should present.
yes, chapter, no, that they will be present once your lordship fixes a time, my lord. And
Any other date can be fixed? Prior to that, no. On 17 July
17 July
at 2 p.m.
at 2 p.m. my lord.
12 noon.
12 noon, my lord.
My lord, I'm appearing for the defendant, my lord. On the last occasion, your
My
lordship
lord, I'm
was
appearing for the plaintiff.
pleased to appoint a commissioner, my lord. Evidence is done, my lord. So
I shall be able to file the report by tomorrow, my lord.
only one thing, my lord, in this matter, I'm appearing for the railway administration, my lord. What happened is, my lord, we have not let any evidence on the plaintiff's examination, and cross-examination has been over in 4 sittings, my lord. I was humbly praying, my lord, because your lordship had directed that the parties will, my lord, share the cost of my lord. Only I was humbly praying, my lord, if the plaintiff may be directed to bear the remuneration, my lord, because it is their witness who has been examined and cross-examined.
What was the original order?
Original order was
Both the
both parties, my lord, because after going through their evidence, my lord, our evidence is not required. That is what we have come
You
to.
will benefit at pay the remuneration. You will benefit at you're telling that as
We
per
have-
the evidence of the plaintiff will not required.
My lord, we have paid our part. Our share has been paid to the commission.
My lord, I was humbly praying, my lord, leave it upon your lordship.
My lord,
So you will not adduce evidence.
No, that is what, my lord, evidence, the
So now
commission
it
is
is a-
concluded. It's
it-
now can be posted for argument,
For
my lord.
argument.
My lord.
my lord, just a premature prayer. If the matter can be fixed for argument before the vacation, my lord, anytime that may be.
For vacation, it is only 3 days is there. How?
My lord, the respondent and defendant have not yet laid any evidence, so the matter.
We don't want
could
to, my
be
lord. We have made it very clear. It's recorded.
It's taking your benefit.
No, no, I'm not taking his benefit, my lord.
Let come after vacation.
It's a commercial division matter, my lord.
Correct. That's why I am
My lord,
fixing.
that is why I thought, my lord, this matter should be disposed. That's why we didn't give evidence, my lord. It's a commercial matter.
When you will file, madam? Tomorrow?
Tomorrow, my lord, matter is fixed for tomorrow.
Counsel for the respective parties are present. Learned Commissioner is also present and submits that she will file the report by tomorrow. Full stop. Counsel for the defendant submits that they will not adduce any evidence on behalf of the defendant, and accordingly, evidence on behalf of both the parties are closed.
My lord.
Full stop. In view of the above, let the matter appear on 18th May for argument.
Very well. Grateful, my lord. Only one thing, my lord, this is a commercial matter. By mistake, it is appearing in a lordship's ordinary
Non-commercial.
list.
Another why is it has come in the original? It is a commercial division.
My lord, tomorrow, my lord, at any time, my lord, I shall file it before.
But you circulate the copy.
My lord,
Circulate.
the order may be given for circulation of the.
The commissioner is directed to circulate the report to the learned counsel for the appearing parties. And unless and until you will not pay the remuneration, I will not discharge her.
My lord, my lord, we already, my lord, because it takes some time for processing, my lord, your lordship can understand, my lord. Otherwise, there is no
Then I will
difficulty.
recover from the judgment.
Well, it will be done, my lord. It will take some time, my lord, because it
I
takes
am
time.
not discharging. Let's see.
Yes, 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 my lord.
Obliged.
Grateful.
Lordship, I am for the petitioner. Lordship, this application has been filed by us seeking exemption from furnishing the administration bond, my lord. Lordship, just to give some background, if my lordship takes up GA 3 of 2023. My lordship sees page 19 of the application.
What is a prayer? Exempted for furnishing the administration bond.
Yes, my lord.
With due security and other order number 9 dated. Order dated census. Yes.
Yes, my lord.
Which page?
Page 19, my lord.
19.
19.
Yes.
Lordship, by way of an order dated 9 January, my lord,
Hmm.
your lordship was pleased to record. My lordship sees for the 4th line. The deceased died on 9th August. The deceased was spinster and died issueless. The parents of the deceased were deceased. The other legal heirs of the father were his brother Kumul Vasudev Shukla, who is also deceased, and Upendra Kumar Shukla, who is the petitioner herein. Their sister Sharda Indubal Bhatt is also deceased, wife of the petitioner. is the only surviving heir of the father of the deceased. So my lord had anyway recorded by way of this order that I am the only heir of the deceased. Considering all this, my lord, considering the prayers made by the counsel for the petitioner and the affidavit of assets, player A is allowed. The petitioner is directed to furnish personal bond of 16 lakhs with 2 sureties. This direction, in my lord, is what I have trouble complying with. If my lordship sees that, then on page 23, I had moved an application and prayed for extension of time to furnish this. Because, my lord, what the issue is happening is that the petitioner, he resides in the United States of America. So for him to get 2 sureties is something which is a huge problem. If my lordship sees my pleading to that effect as well at page 3, my lord. If my lordship sees page para 9 on page 3, for a surety to provide a personal bond.
Para 9?
Para 7 and 9, my lord, on page 3. My lord, I am led by
Please continue.
If my lordship sees para 7, lordship, due to the petitioner residing in the United States in America, for me to get 2 sureties and their permission, I have to approach the Reserve Bank of India and get a lot more approvals. And this is something which there is an impossibility to perform on my end. So, my lord, this is the factual background. There is law to that effect as well. My learned.
Lord, the only issue is, my lord, that under the Succession Act, when you get a letters of administration or you get, my lord, a probate, you're appointed as administrator, the act requires you to furnish a bond. The bond, my lord, is for the purpose of security of the estate. Indemnity. Yes, indemnity bond. Now, my lord, where you're yourself the sole legatee and you are to be appointed as the administrator, there is no necessity of the bond. Because the bond is essentially for your own benefit. Correct. There is no judgment of this honorable court, but we found, my lord, a series of judgments of the Delhi High Court, at least 7 or 8 of them. Now, your lordship would perhaps think, my lord, that why would a person not want to give a small bond? My lord, the issue is, I am a resident of America. My entire family is, my lord, residing in America. Now, if I have to have somebody, I don't have somebody very close to me in India who would actually give a 30-40 lakh rupee bond for me. Now, if I have to get somebody to give a bond, I would have to secure money to him. That same money I have to give him, he'll give the bond. Now, if I do that, I need RBI compliances, which is why, my lord, I have requested your lordship for 2 extensions in the past. It's becoming unworkable. Then, my lord, we were asked to find a solution. And while researching, my lord, we found that it is where I am the sole beneficiary. Your lordship, my lord, may be pleased to dispense with it. May I show the section once and then the 2 judgments? My lord, please see, my lord, section 291 of the Succession Act. Every person to whom any grant of letters of administration other than a grant under section 241 is committed shall give a bond to the district judge with 1 or more surety or sureties engaging for the due collection, getting in and administering the estate of the deceased, which bond shall be in such form as the judge may by general or special order direct. And then 2B, it also extends to probate. Now, my lord, kindly consider the first judgment, which is of the Delhi High Court in a probate matter. This is the first one. Ishan Kapoor is the first. Oh, Sanjay Suri is the first one. Sanjay Suri. Mark Coroni. This is a probate matter, but this principle was later extended to grant of letters of administration. Lord, please see paragraph 1
petitioner Sanjay Suri filed a petition for grant of probate or letters of administration, seeking a probate. Then my lord, paragraph 3. The petitioner is it is, let's say, fourth line, paragraph 3. It is claimed that the petitioner is mother, respondent number 2, and daughters relinquished their shares in the property, and property was mutated. Petitioner seeks probate. Notice was given. Now, my lord, kindly come straight down to paragraph 11. An interesting question has arisen at this stage as to whether the petitioner is required to execute an administration bond or not. In this context, it may be noticed that initially learned counsel for the petitioner had sought to urge that since the petitioner was the sole beneficiary under the will and was being left to deal with the property as an owner, impliedly, he was to act as executor also. In other words, this was an appointment of an executor by implication. Learned counsel, after some arguments, did not press the same. Then, the requirement for execution of an administration bond is as under section 291, my lord, is quoted. Then paragraph 13. Barring the exception being provided for an eventuality for the grant of letter of administration to an attorney of absent executor, section 291, as noted above, mandates furnishing of a bond to the district judge in every case of issuance of letters of administration. Learned counsel for the petitioner argued that the requirement of execution of the bond should not operate in the case of a sole beneficiary under the will to whom letter of administration are granted. Probate is not being granted only on account of bar under 22. Had the petitioner been, well, that's a different matter. Now, my lord, paragraph 15. The object, my lord, I don't want to read, my lord, the first 10 lines. Middle of the paragraph, the statutory provisions and rules, Lordship has seen that, Lord, and rules are to be interpreted in a manner which would give effect to and further the intention of the deceased, rather than to act in a manner which would have a converse effect on what was contemplated by the deceased. It is in this background that we have to consider the requirement of furnishing an administration bond by a sole beneficiary under the will. The legislature, when enacting section 291 of the Act, would have no reason to believe that in ordinary circumstances, the deceased, while making his or her last testament, would fail to make a provision for the implementation of the testament. Then it goes on. Last 4 lines of the page. It is for this reason that sufficient safeguards were provided, etc., to safeguard the interest of all heirs and others having an interest. Then paragraph 16. Section 291 of the Act requires furnishing of an administration bond. The object of an administration bond is to secure due and proper administration of the estate of the deceased, in which the executors and administrators have to discharge multifarious duties, etc. And then payment, not the logical part. Now, my lord, paragraph, page 452, end of paragraph 19, just before paragraph 20. There was in one judgment, this was dismissed, that was distinguished. And paragraph 21. The crux of the matter arising for consideration is whether a sole beneficiary under a will, which has been duly proved, should be required to execute an administration bond for the administration of an estate which is bequeathed to him and to which there are no other claimants. It is only on account of statutory bar under section 222 of the Act, the sole beneficiary natural heir not being an executor, is not being granted probate. It is not in dispute that had he been appointed as executor, there would have been no requirement or insistence on furnishing a security or administration bond. And then, my lord, paragraph 28. Considering the nature of testamentary and intestate succession, the object and purpose sought to be achieved by section 291, and thus applying the aforesaid principles of interpretation of statutes it would be seen that section 291 of the Act is not intended to cover within its ambit the cases of a sole beneficiary and legal heir under a will being required to furnish administration or surety bond. One cannot administer the estate or his own estate against himself, for which he may be required to give an indemnity or administration bond. Besides, none of the purposes and objectives of section 291 of the Act are covered or fulfilled by the execution of an administration surety by the sole inheritor or beneficiary under the will duly proved. Such an exercise would be an exercise in futility.
Yes.
And then the last two lines of the page, section 291, in the light of the foregoing principles of interpretation, as noticed, has to be interpreted so as not being applicable to a case of a sole beneficiary and legal heir under a duly proved will, insofar as requirement of furnishing an administration bond is concerned. This, my lord, is the parent judgment. Now, this principle was extended to, my lord, letters of administration also. In Richa Pardesi's case, my lord, kindly you have a look, my lord. Lord, paragraph 10, adverting to the contention of the petitioner's counsel that the petitioner should not be required to submit an administration bond, surety bond, it would be apposite to note the provisions of section 291 of the Succession Act. Paragraph 11. Thus, section 291 of the Act, except in the exceptional circumstances enumerated in the section, requires furnishing of an administration bond by every person to whom any grant of letters of administration is made. The object of an administration bond is to secure due and proper administration of the estate, etc., etc. Milord, then again, sole beneficiary, I'm not, Milord, reading. Last three lines, this is the paragraph, Milord. Last three lines, to require such a sole beneficiary under a will to furnish administration surety bond would be meaningless in view of the fact that he cannot be asked to give an indemnity against himself. Then Halsbury's Law of England is, Milord, quoted. And paragraph 13, learned counsel for the petitioner submits, and I think rightly so, that there is no reason why the enunciation of the law relating to the aforesaid case dispensing with furnishing of administration in the case sole beneficiary should not be made applicable to the case of a sole beneficiary upon whom the estate of the deceased devolves by intestate succession. The object of the law of succession, be it testamentary or intestate in nature, is to enable the court to lend its seal of approval to the succession of the estate of the deceased. And therefore, my lord, paragraph 16, petitioner was exempted from furnishing an administration bond. This is, my lord.
But on the paragraph 13, it tried that the judgment given in the exercise of both testamentary and intestate is judgment in rem.
Is judgment in rem. It will, my lord, cover the whole world. So, my lord, nobody can really say anything.
Oh.
Now, this, my lord, the requirement of furnishing a bond was found to be harsh, paragraph 4, and dispensed with. So, my lord, it's not just sole beneficiary. Now, courts, my lord, are seeing that even if it's harsh, it can be dispensed with. My lord, another school of thought I am entitled to waive a mandatory provision of law which is for my benefit. My lord, please have a look at 2013-10 SCC, page 83. This was a surfacey case.
What is the law?
My lord, paragraph 19. This was regarding, my lord, private sale. Please come to paragraph 19, my lord. There is no doubt that rule 9(1) is mandatory.
Okay.
But this,
Mandatory provision can
yes, mandatory provision
always
for my benefit
can always
can be waived by me. My lord, this is private sale. It's to the same effect, my lord.
If in your case, okay, you are not able to give the personal the security, you can give the personal indemnity.
Yes.
You can give the personal indemnity.
Yes, yes, no difficulty.
At the time of grant.
Yes, I can give a personal indemnity. I can give an undertaking to court,
Correct.
which would result in contempt. All that I can, my lord, easily do. I can apostolate and have it brought. There is no difficulty. Lordship would permit that, my lord, and waive this.
Thank you.
Grateful to your lord.
Hearing concluded. Fix the law. Next.
11 is my application for probate, my lord. Lordship looks at the last order dated April 12th, 2023. There were two aspects, my lord. There was a report filed by the department saying that there are two discrepancies in my application. The first is with respect to the fact that one of the legal heirs, Rita Goel, who's filed an affidavit of consent, my lord, that affidavit is without a notarial certificate, which your lordship knows now is the rule. And the second aspect, my lord, there were two assets, my lord, in serial number 3 and 4 of the will, which did not form a part of the affidavit of assets. Now, with respect to the first, my lord, I already have it. I haven't been able to file it with the department. I've received this yesterday. I'm willing to file this before your lordship here and now. With respect to, my lord, the second, there's a supplementary affidavit that I've prepared that I'll not claim any of the assets as a part of serial number 3 and 4. That your lordship is prepared, but it's not been affirmed. I'll affirm and file.
The time.
I'll file it within the course of the day today.
I am extending the time. You file it.
Very well.
After
I shall file both.
Counsel for the petitioners present. The registrar insolvency, original site has submitted the report. So counsel for the petition submitted in terms of the report, the petition have already taken steps and prayed for a day's time. In view of the submission made by the counsel for the petitioner, time to comply with the report of the registrar insolvency is extended for a further period of 1 week.
Lordship, may I just renew my prayer, my lord? This will be filed within the course of the day. Would it be your lordship's pleasure to keep it any time this side of the vacation? This will not take more than 5 minutes.
Correct. Come after vacation.
Very well, madam. As your lordship, please.
Let the matter appear within a week. Let the matter appear on 7th June. 7th June.
Very well, my lord. I shall come. Thank you.
12 in this matter, my lord, last Friday, the matter was appeared before your lordship as item number 64. And I was mentioned the matter, my lord, at the time of rising, my lord. Your lordship fixed the matter on 3rd of July at 3:45 p.m. Again, the matter was came up before your lordship as to be mentioned.
Why? It is mentioned.
I don't know, my lord.
My lord, I am for the applicant, my lord.
Well, I am the caveat.
No, actually, the matter is fixed on 12th May.
12th May.
So now it already fixed the matter.
Already
a
fixed
date
the
is
matter, but your lordship can see it at 2 o'clock. I was mentioned the matter on 12th at the time of rising.
Already date is fixed.
Yes, 3rd of July at 3:45 p.m.
Okay, come on.
3rd July.
3rd July at 3:45.
I don't know, the matters came up wrongly appeared here. In Namdal.
This is my application for rejection of plaint
Yes.
on the ground of, my lord, intervention of subsequent events. My lord, very briefly, my lord, the plaintiff filed a suit against me claiming a sum of money.
Which for the other side? Somebody say.
Sir, I'm for the plaintiff. Sir, kindly allow short passover. Senior is another courtroom.
My lord, this has happened, my lord, time without number. My lord, the matter has been passed over. My lord, kindly allow me to, my lord, just make my very short submission.
Your application for?
My application for rejection of the plaint.
Yes, ever.
Well, I'll just tell you, lordship, very briefly the background. Plaintiff files a suit against the defendant claiming a sum of money. Well, plaintiff also files an application under Chapter 13 for summary judgment in the suit. In the meantime, my lord, the defendant company is, my lord, sent into CIRP. Insolvency commences. My lord, there is a resolution of the insolvency. My lord, the company is transferred to another entity. My lord, that entity now, my lord, substitutes to become a defendant. That company, my lord, took the point before the, my lord, learned single judge in the, my lord, Chapter 13A application, saying that now, by reason of intervention of law, all debts against, my lord, the company, my lord, under the law, extinguish. Now, my lord, in view of, my lord, that position of law is now clearly established by the Supreme Court, my lord, the learned single judge dismissed, my lord, the Chapter 13A application, but the suit survives. My lord, for no purpose really, but the suit survives. My lord, we have now said, my lord, this suit cannot continue because, my lord, your lordship has allowed the substitution of the new entity, my lord, post resolution of insolvency. My lord, that is now the defendant, and his stand is very simple, that I am liable only to pay whatever debts are, my lord, foisted on me by the resolution plan, nothing more. So, my lord, this debt extinguishes, the suit does not survive anymore. My lord, I am, my lord, armed by judgments which says by reason of intervention of subsequent events, my lord, suits can, my lord, perish. My lord, that's number one. Number two, the law on the subject that, my lord, all debts stand extinguished is now, my lord, very well settled by the Supreme Court in Ghanshyam Mishra's case. But that is, my lord, my short point, nothing more.
Yes.
My
Have you
lord,
filed the
kindly allow short passover.
Short passover? No. Who is your senior?
Casey Garg.
Affidavit filed? No.
Yes. No. In this application, my lord, directions were obtained, but no affidavit was filed.
Yes, December 2021, there is a direction. Do not file affidavit in opposition.
My lord, affidavit is ready, but signature of the client is missing. Today he is coming.
It's a question of law. My lord, there's no, my lord, factual, my lord, assertion to be made.
He was out of his
Her
station.
senior is not here. Can we pass it to? Or any date can be fixed?
Well, kindly fix a date, but kindly make it peremptory.
Counsel for the plaintiff is present. None appears on behalf of the defendant. Counsel for the plaintiff is present. Counsel for the defendant prays for time. It is fine from the record. Time and again the case is adjourned on the prayer made by the counsel for the plaintiff. In view of the above, let the matter appear on date. Let the matter appear on 8th June 2023.
It will take very short time. So it will take 10 minutes.
It is made clear that on the date fixed, no adjournment shall be.
Grateful.
So this is my application, my lord.
For?
My lord, probate was granted, my lord, on 23rd December 2016, my lord. My lord, thereafter, my lord, I could not file, my lord, inventory and accounts, my lord.
2016?
Yes, my lord.
And today we are on 23.
My lord, my
What has happened for
father-
the 7 years?
My lord, my father was ill, my lord, he was suffering from cancer, my lord. And my lord, thereafter, my lord, he died, my lord.
Since when he was suffering from cancer?
My lord, kindly see, my lord, Annexure A, page 6, my lord. My lord, he died in 2020. My lord, he was suffering from cancer, my lord.
20 died. Then now we are on 23. What is
Thereafter, my lord, COVID comes, my lord, that is why, my lord. Kindly, my lord, condone the delay, my lord. I'm the only daughter, my lord, to look after my father, my lord.
Probate was granted on 23rd December.
My lord.
And when the probate certificate was issued? Can you come to the
Issued on 3rd February 2017.
certificate was issued on 3rd
My lord.
February?
My lord.
Counsel for the petition is present. The petition has filed the present application, praying for extension of time to file inventory and accounts. Full stop. Counsel for the petition submitted by an order dated 23rd December 2016. This court has granted probate, and on 3rd February 2017, probate was issued. Full stop. Due to illness of the father of the petitioner, subsequently the father of petitioner died in the month of October 2020, and in the meantime, COVID was also affected, due to which the petitioner could not file the inventory and accounts, and prayed for condoning the delay and allowing the petitioner to file inventory and account. Consider the submission made by the counsel for the petitioner, peruse the application and documents. This court find that sufficient cause has been shown for non-filing of the inventory and accounts within the time prescribed by this court. Accordingly, prayer B. Is allowed with the direction to the plaintiff to file the inventory and accounts within a week after opening of summer vacation. Opening of the court after summer vacation.
Grateful, my lord.
GA number 2 of 2023 is disposed of. E1 and 2. Okay, true.
This is my application, my lord.
You're for the defendant.
I'm for one of the defendants. GA number 3.
I'm appearing on behalf of Mrs. Manju Agarwal.
May I file the affidavit?
You filed an application for?
Yes, this my lord, my application, my lord, is seeking expunging of my name from, my lord, the array of defendants in the suit. This is, my lord, a partition suit filed, my lord, by a member of the family, and my lord, I am a company. Now, my lord, I'm an independent juristic entity. I'm incorporated by individuals. The plaintiff is neither a shareholder nor a director, never has been a shareholder nor a director. And, my lord, he seeks, my lord, to, by making me a party, my lord, to get orders, declaration and orders, my lord, of partition insofar as the property is held by the company is concerned. Lordship is aware, my lord.
The companies of your own.
I'm sorry, my lord.
Companies of your own only.
Yes, it's owned by a member of the family, but it's completely different. There's no family corpus involved in the company, never been involved. Obviously, the company has some properties, which is why, my lord, it's been impleaded, and, my lord, orders of restraint are sought, my lord, and ultimately, my lord, partition of the company's property as that of the families.
Yes, madam.
Your Lordship, I will pray that the matter be kept after vacation, as Mrs. Agarwal is in Madras right now and her brother is critically ill.
So many long time she's.
So the condition got worse, so she had to leave on Friday. And your Lordship, I would like to file original affidavit in reply in G application 600 of 19 and affidavit in opposition in G application number 3.
J3.
Yes,
GA 600, my lord, is their application seeking, my lord, certain interim orders, where, my lord, there's an order of status quo passed and I'm suffering that order of status quo.
So when can be fixed?
After 2 weeks after vacation, so your Lordship.
Vacation. How long it will go, madam? We appreciate you.
I apologize, sir, but his condition is critical right now, very critical.
Counsel for the respective parties are present. Full stop. The plaintiff has filed affidavit in opposition in connection with GA 3 of 2022 and GA Another
600 of 9.
600 up to the 19, within bracket GA1 up to the 19. And the counsel for the defendant has filed, defendant number?
I am defendant number 6.
Defendant number 6 has filed affidavit a reply in connection with GA3 of 2022. Let the same be kept with the record. Counsel for the plaintiff pressed for time due to personal difficulties.
How does he know?
Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 15th June.
My lord, only two things, my lord. The replies which have been filed today, could copies be, my lord, served on us?
We'll serve them.
And
The counsel for you have served the copy.
the opposition, yes.
The counsel for the plaintiff is direct to so the copy of the reply to the learned counsel for the defendant.
And my lord, slightly, my lord, embarrassed, but let it be understood on the 15th, my lord, they'll not pray for further adjournments. my lord.
Let it come. And this I don't want to pass any.
I know, my lord, that's why I said slightly embarrassing as well. Grateful, my lord.
Great reminder.
Why it has come? Item number 17. ELA 420. It is dismissed. Already dismissed. 17. GA2. Who is there? Let me also be dismissed now. That was the amendment. Just no, it is fine from the record. PLA number 425 2019 is already dismissed for default by an order dated 18 January 2023. Full stop. The petitioner has filed GA2 of 2023. Saying for amendment in the application, but already the application is dismissed for default, and as such, GA2 of 2023 is also dismissed.
Item number 18 is my application, Lordship, for discharge of the executor. Lordship, we had filed a supplementary affidavit indicating, Lordship, they had made certain claims as to the amounts payable to the executor for taking out this instant application, Lordship. So we'd used a supplementary.
My Lordship would recall, my Lord, on the last occasion, my Lord, the life insurance corporation and the banks had been discharged.
Yes,
And my Lord, we were supposed to, a meeting was convened on Friday as to how the matters or the issues can be amicably resolved. Now, my Lord, I was only humbly beseeching your Lordship, if the matter can be kept 2 weeks after vacation, my Lord, the funds which have come into the estate, let the disbursals be made. My Lord, thereafter, my Lord, subsequent steps can be taken.
Yes, my Lord, the funds have come in and that can be disbursed. Lordship, in that meeting, we'd also discussed as to how and what is going to whom. Lordship, with regards to what we've stated in the supplementary affidavit, we can come back and press our application with regards to that because
What do you
Lordship,
say for
because
the supplementary
Lordship,
affidavit?
because in the supplementary affidavit indicated 2 emails, but Lordship, the executor had written to one of the beneficiaries, that is the applicant, Lordship, that 16 lakh rupees is due in
That is
payment.
earlier occasions.
Yes, Lordship. After that, we've convened the meeting, Lordship.
Okay, you prepare this whatever it may be. I am fixing after 2 weeks.
Very well, Lordship. Very
In
well.
the meantime, if the matter is settled, it's okay. Otherwise, will the matter
Very
be
well.
decided
Lordship
on
keeps the matter pending. In that case, keeps it after
I am
we.
not passing any
Right.
order. I am only shifting the matter after 2 weeks.
Yes, grateful, my Lord.
Meantime, Lordship, if the sums can be disbursed, Lordship,
Yes, that will take steps, my Lord, that since, my Lord,
Lordship will kindly record that they'll
What?
take steps because the sums have come in.
Automatically, I have to take steps, or else they'll come and press for their application for my removal.
Because this has been pending, we have to take out an application for that.
Let come on the next day. If they will disburse, it's okay. Otherwise, the court will.
Lordship.
Counsel for the respective parties is present and submit that there is a chance of settlement and press for 2 weeks' time. In view of the submission made by the counsel for the respective parties, let the matter appear on 13th June.
13th June.
Right. Great.
My lord, with regard to item number 17, my lord, my matter was going on, my lord. My lord,
17 already you have filed with GA, but prior to the main application was already dismissed.
restored by my lord.
When it was restored, there is no order of restoration.
There's a restored. GA, this is GA, GA2, GA1 was there. I had filed one GA1. It was already restored, my lord. I have a copy. It was restored, my lord. The application was dismissed for default. It was restored, my lord. If my lord keeps
No.
tomorrow,
Where is the order of restoration?
my lord, I will bring it to you. That brief is not with me, my lord. I will bring the order
So
tomorrow.
I already dismissed your GA2 also in view of the dismissal of the order.
That has been restored, my lord.
When it is, where is the order?
My lord, that order is not with me today. My lord, I can bring it tomorrow, my lord. GA1, I had filed 2 applications. GA1, my lord, was pleased to allow the application and restore that to its original file, my lord. Or if my lord takes up at 2 p.m., I can bring the order.
Just a minute. When you have filed this GA2,
GA2 was filed on
20th March.
20th, on the same day that GA1 was also filed. And it was taken up on sometime in GA. The application was allowed by my lord.
Where is the GA1?
GA1 was the separate 2 applications were there.
Okay, then that order. Let it be fixed on 6th June. As per the prayer made by the counsel for the petition, let the matter appear on 6th June. Next. Give your name.
My lord, in this matter, I am appearing on behalf of the plaintiff. My lord, the plaintiff is the executor who had taken out the application for probate. Subsequently, my lord, it was marked as a testamentary suit in the year 2015. My lord, here I would be making 2 innocuous prayers, my lord. The beneficiary of the will is an octogenarian lady. She is bedridden at the moment, my lord. She is the one who is supposed to divorce before your lordship and, my lord, take the endeavor of proving the will. My lord, in that regard, my lord, I was making a prayer if my lord can appoint.
Who is for the other side?
My lord, the caveat has been lodged by one of the daughters of the deceased. My lord, unfortunately, they have not been appearing for a long time. It's only that they have lodged their affidavit in support of caveat, pursuant to lodging of the caveat. But since then, my lord, at least I have not seen them appearing in course of many a times when the matter has been called, my lord. My lord, I would be beseeching your lordship to kindly appoint a commissioner.
No, but on the last occasion, February, you stated that the plaintiff is a old age lady and she is in
Yes, my lord.
USA.
Yes, yes.
Has she returned back?
Yes, my lord.
She is in USA.
My lord, she has returned. She has returned, my lord. She had gone to US for the treatment. But my lord, she has.
She is visiting the USA for treatment. Why she is not coming to the court for deposing?
My lord, there is some impediment, my lord. If the commissioner is appointed, my lord, I would have this inclination that this exercise would be completed, my lord, pretty, my lord, soon.
Counsel for the plaintiff is present. None appears on behalf of the defendant. Counsel for the plaintiff submitted. The plaintiff has already returned from USA, but she is old age lady and suffering from various ailments and is not in a position to appear before this court. And thus the petitioner intend to, and thus the plaintiff intend to examine the plaintiff through commission.
Yes,
Police. In view of the submission made by the counsel for the plaintiff. Yes, you can. Commission. Mr. Chen
Ratul Das, my lord.
is appointed as commissioner for examination of the plaintiff on commission at her house. Where is the address?
My lord, presently, my lord, she is here in Calcutta. My lord, we'll disclose the address to the commissioner once he is officially appointed and he gives us a notice to the effect.
Not outside.
No, my lord, no, not outside, not outside.
So and so at her house. Full stop. The remuneration of the commissioner is fixed rupees 15,000 per sitting. Per sitting. Full stop. The commissioner shall inform the date of examination of the witness on commission to the assistant registrar of this court, so as to enable the officials of this court to produce the record before the commissioner at the time of examination of the witness on commission. The commissioner shall complete the examination of the witness. Shall complete the examination of the witness on commission within 30 days. Let the 30 days. The commission is directed to file report on 26th June 2020.
My lord, I would be making one more humble prayer, my lord. My lord, since she is an octogenarian lady, my lord, there is some monies which is lying to the credit of the deceased, my lord, his bank account which was operated by the executor. My lord, she has expressed a desire to, my lord, distribute whatever money is lying to the credit of those bank accounts, to distribute an equal share amongst all her 3 daughters. My lord, can make a direction to that effect.
Not at this stage. Let first examine that. I will.
My lord, because she has expressed a desire to distribute the assets.
Correct. Let come on evidence.
I'm extremely grateful, my lord. Extremely grateful.
26 June.
That I'm appearing for the plaintiff in this matter. My lord, the suit, the witness action in the suit has been completed and the suit was also heard at length. Thereafter, my lord, due to change of determination and subsequently COVID intervening, the matter was not taken up. My lord, if I may start, since my lord, I would have to start before my lord de novo, if I may start with the arguments afresh, my lord.
Who is for the other side?
My lord, Mr. Aniruddha Mitra was appearing for the other side along with Mr. Dhilan Sengupta. My lord, they had been appearing and this matter, my lord, was listed twice. And my lord had placed it on the to be mentioned list and thereafter fixed it for today.
Yes. Nobody is there. You can start your.
May I start? Yes, my lord. This is a suit for recovery of sums that was advanced by way as a loan or a financial assistance by one individual to another individual. The plaintiff is Topon Ranjan Mainti. He is the person who had advanced a sum of rupees 13,78,000 to the defendant, who is Shamol Sarkar. The reason I indicate the nature of the legal nature of the plaintiff and the defendant is for the purpose to indicate that this is a one-off loan that was provided by the plaintiff to the defendant. He is not a money lender or did not really work for any advance. My lord, if I may start with the plaint, my lord, my lord,
How many witnesses you are reduced?
There was only the plaintiff had come in the box. He was adduced. He has adduced evidence, cross-examined.
And defendant?
The same defendant had was brought to the box. He was cross-examined. The cross-examination is also concluded. The entire process was concluded. If I may indicate the last date of cross-examination, my lord, this was cross-examined till 26th of August 2019, when the defendant's witness was in the box. And the matter was thereafter, the cross-examination was concluded, evidence was closed, and it was fixed on for arguments on 12th of September 2019. Subsequently, several hearings had happened and arguments were forwarded by both parties. My lord, if my lord also is pleased to take up the order dated 26th June 2018, where the issues have been framed. My lord, may I take my lord through the plaint and the issues simultaneously? I will just give a brief overview. 26th June 2018. Yes, my lord.
My lord, there are seven issues which were framed. But before I get into the issues, my lord, let me take my lord through the facts briefly. Now, this is a very short matter. My lord, in 2009, the plaintiff case is that in 2009, the defendant had approached the plaintiff for the purpose of, because he was in some urgent need of money. And thereafter, my lord, at paragraph 2, page 3 of the plaint, I have indicated, the plaintiff has indicated that 13,78,000 was advanced to the defendant between 8th of December 2009 till 21st of March 2010.
Yes.
And this entire sum was advanced and the agreement was executed and the entire sum was advanced from the plaintiff's office at 12/2 Madan Mitra Lane, Kolkata 6, which is within the jurisdiction. The address was wrongly indicated as residence. Subsequently, when the witness had come into the box, the plaintiff's witness in the box, he has indicated this was not my residence. This is where I used to conduct my business. I will show that from the evidence subsequently. So at paragraph 2 is the indication of the amount that was made over there on 8th of December 2009. 32,000 was made over. On 15th of December 2009, 9,74,000 was made over. On 1st of March 2010, 25,000. And again on 12th of March 2010, 5,000 more. And 10,000 on 10th of March, 50,000 was made over. Finally, a tranche of 2,92,000 was made over on 21st of March 2010. My lord will kindly take note of this fact of this last tranche. I will come when I come to the written statement, I will indicate why. And this entire amount was paid, or this 2,92,000 was paid on 21st of March at one go, on 2010 at one go. My lord, thereafter, the plaintiff indicates that there was an agreement between the parties for payment of interest. Since it was a loan that was advanced because of urgent need, interest was decided to be payable at 6% per annum. And at paragraph 4, the defendant had also made over certain payments to the plaintiff, and he had made payment of 1,06,000. This payment was made in 4 tranches, which is indicated in that paragraph.
Yes.
And I shall indicate that with regard to paragraph 4 and the quantum of the amount that was made over, there is no dispute between the parties. There is dispute with regard to the amount that was received, but with regard to paragraph 4, there is no dispute between the parties that this is the sum that was made over.
So what is the dispute?
My lord, yes, my lord. The first, if my lord now takes up the issues, I would indicate that the first dispute was with regard to the cause of action and the place where this particular agreement was entered into and payment was done. That is the first cause of issue with regard to the cause of action and the jurisdiction of this court. The second issue was whether at all there was an agreement and to what extent, because my lord, the plaintiff has pleaded a case of oral agreement. There is no, rather there is no concrete document to show that this would be the entire transaction. The plaintiff has in the plaint.
How you have proved with regard to the,
yes, ma'am.
We have given the 5.
There are money receipts. There are money receipts, regular basis, all these 6 tranches, that 7 tranches.
That exhibited.
Those are exhibited. I shall come to them one by one, my lord. So, my lord, there are money receipts, but the issue was raised whether there was an agreement, because as I had indicated, this was given as a loan. Now, if my lord, I take my lord through the written statement, I will indicate why it became an issue, because the reason or the purpose for which the loan was granted was brought into question. And my lord, thereafter, the third issue that was there is with regard to fraud being perpetrated in order of the signatures appearing in these money receipts. The defendant had claimed that these signatures were obtained fraudulently. And thereafter, my lord, are the 3 issues with regard to the quantum, which I have to prove that 13 lakhs was the amount that I had made over, and the 14 lakhs 82 is the amount that I would receive as on the date of filing of the suit, and with regard to interest and further reliefs. These are the main issues. My lord, also, perhaps I should have indicated or rather place the written statement before taking my lord through the issues. My lord, the written state, if my lord takes up the written statement, this was filed on 27th of January 2017.
Yes.
My lord, the first 6 paragraphs are his averments with regard to the suit not being within the jurisdiction should be dismissed. The formal paragraphs. My lord, I will take my lord's attention to paragraph 7. No part of the cause of action, if any, has arisen within the jurisdiction of this honorable court. The jurisdictional facts pleaded at paragraph 1, 2, and 7 of the plaint are false and false to the knowledge of the plaintiff. The plaintiff was not at the relevant point of time a resident of 12/2 Madan Mitra Lane, Kolkata 7,06,000. Even otherwise, there was never any agreement entered into by and between the parties at that address. So this becomes an issue with regard to the cause of action. Then, my lord, the relevant paragraph is paragraph 10, where the defendant makes an averment that the documents annexed to the plaint are forged, fabricated, and manufactured. The signatures of the defendant were procured on the said documents by the plaintiff by perpetrating fraud and on false and fictitious pretexts. The defendant had signed on some money receipts at the instance of the plaintiff and in good faith. It, however, now appears that the plaintiff has made various interpolations in the said money receipt in order to give a false impression to this honorable court. So the allegation first was that it was perpetrating fraud, but then the defendant admits to signing on the money receipts. And his only claim is now that there has been various interpolations on the money receipts. And that is the extent. So he does not really dispute the fact that he had signed these money receipts and the documents. Now, my lord, I have made out a case in the plaint that the money was given to him because he was in urgent need of money. That was the extent of my statement in the claim. Whereas at paragraph 11, is where the defendant tries to now make out a case of his own, where he indicates that the defendant by occupation is a driver of Calcutta State Transport, now West Bengal State Transport, contrary to what have been falsely alleged in the plaint. The parties had entered into an arrangement. Sometime in or around February 2007 to carry on business in partnership with one another. The plaintiff knew the defendant to be well acquainted with persons, dealers engaged in the trade of buying and selling of used cars and motorcycles. The business is also very pertinent, used cars and motorcycles. The plaintiff had approached the defendant with a proposal that the plaintiff would provide the defendant with funds for the purpose of acquiring used motor vehicles, which would ultimately be sold by the defendant at a profit. It was further understood that the principal sum invested by the plaintiff would be returned together with an additional 6% thereon as share of the plaintiff's profits. So now he tries to make out a case that there was an agreement for partnership, and he also admits that he was supposed to give a sum of 6% as share of profit.
Has he produced any document?
Yes, my lord, will kindly continue reading the written statement, my lord. The defendant had received a sum of 2,92,000. So now he admits receiving 2,92,000 from the plaintiff in tranches on different dates. This is why I wanted to indicate that 2,92,000 was made over by me on 21st of March 2010 and not in tranches. And my lord, the fact that this 2,92,000 has been made over is admitted by him. But what he's trying to indicate, he is trying to indicate a timeline of February 2007 when these tranches there was start of making payments. But in the plaint, the cases that payments were made from 2009 to 2010 March. Thereafter, out of the aforesaid sums, defendant acquired used motor vehicles with the intention of reselling the same at profit. The defendant has since not been able to gain profit, and accordingly, the defendant has repaid a sum of rupees 1,06,000, which comprises of a principal component of 1 lakh and share of the plaintiff's profit of 6% thereon. So far as the balance 1,92,000 is concerned, the defendant is ready and willing to refund the same together with agreed share of the plaintiff's profits. So, my lord, he admits that there is a 6% amount which was to be payable, which I am claiming is on account of interest, but he is trying to make out a case that this was paid on account of a share of profits. And the fact that he has made this payment of 1 lakh. This fact, as I had indicated, is not disputed by both the parties that 1,06,000 was returned. And there is an admission of 1,90,000.
You have not filed any application for judgment on admission?
No, my lord,
with
no,
regard
my
to
lord.
display?
I have been inducted at a later stage when the evidence was at the stage of starting. There was an interlocutory application, but because of certain disputes and certain misstatements in the plaint, that application was disposed of, my lord, and this matter was sent to trial. My lord, thereafter, so there is an admission with regard to 1,92,000 and an admission that he would be making payment of 6% thereon. So this amount is admitted. Again, I will only just quickly take my lord through certain statements in the written statement. Paragraph 13, my lord will come to the last 4 lines, that last 3 lines, that as aforesaid, a sum of 2,92,000 was given to the defendant on diverse dates, but not by way of loan or advance, but in pursuance to an arrangement. So he admits this once again. And at paragraph 14, the second line, page 6, the last 3 lines, again he admits that 1,06,000 was made over, but he denies that the manner in which it was paid off. And then he states in paragraph 14, at page 7, there was never any request or demand made by the plaintiff for refund of the sum of rupees 1,92,000, which was lying in the hands of the defendant. And then he states it was only through advocate that the plaintiff for the first time with a notice dated 16th of July 2012 purported to raise a false and fictitious claim. So on 16th of July 2012, he admits to receiving of the notice and the demand that was made. I will also take my lord through other documents which would reflect that prior to that, several other steps were also taken by the plaintiff. And the same fact is again narrated in paragraph 15. So at paragraph 15, he again admits to the liability of 1,92,000 together with 6% share of profit. Therefore, my lord, the defendant has not really disputed the claim that has been made by the plaintiff. If now, my lord, if I may take my lord through the depositions and the additional documents which were filed. The documents may be taken up together with the deposition, my lord. The first annexure is a money receipt. It would be a pound
addition.
No, my lord. Judge's brief of documents. There is one addition that will come to later on. The first document is the document at page 7. And this is a document dated 8th of December 2009. My lord, this document is in Bengali. However, my lord, a translation of this document is appearing at page 8.
Yes.
Now, my lord will kindly take, if my lord so pleases, my lord will take the deposition side by side. That will inure to my lord following what the deposition was. Question numbers 17 onwards. 17 to 27 are the relevant questions in respect of the document appearing at page 7, exhibit which was marked exhibit A.
Question 17 to
27.
yes.
Yes, my lord. If my lord looks at the first few questions, it is indicated that this was a money receipt which was signed by Shamol Sarkar in my presence. It is the original money receipt. The money receipt was executed on so and so date. This is my handwriting. It was his handwriting. Shamol Sarkar has written the receipt and put his name. So the signature appearing on the particular document is over the stamp. There's a 1 rupee revenue stamp on the document. Right over the stamp is the signature of Shamol Sarkar. And the particular signature is encircled in red pencil, my lord. And question 24 is where it is indicated that he had taken a loan of 32,000, which he was supposed to repay. Now, question number 25 is important. Do you find any alteration on the original document? So the witness now answers, firstly, he has sought rupees 30,000. Later, he has asked for 2,000 more. So I overrode the figure of the amount. If my lord kindly comes to page 7, my lord will see there is, my lord will see at page 7, there is an interpolation where a 0 is made into a 2 at the on the second last line.
Yes.
So this is the interpolation, my lord. Again, I go back to the written statement where an allegation has been made that I had interpolated certain documents for the purpose of showing that these monies were received by him. And this document, the only extent of interpolation in this document is this 30, which has been made into 32. And all the other indications in these documents were there before or at the time when the defendant has signed the document. The defendant does not dispute his signature. My lord, this document was tendered at after question 27. We had tendered this document. Now, my lord, the next document, this is again from paragraph 2 of the plaint. My lord, the first entry of 32,000 is proved by this document. Now, I come to page 9 of the judge's brief of documents, my lord.
What is the cross-examination on this?
My lord, cross-examination. My lord, would it be my lord's pleasure if I just go through the documents and then come to the cross-examination, my lord? My lord, thereafter, the next document is at page 9. This is a document where there has been several writings made.
Yes.
My lord will see at the top of page, this is again in vernacular, but at the top it is Maiti Suppliers, proprietor Taponaranjan Maiti, 12/2 MM Lane, Kolkata, MM Road, Kolkata 6. So the address is mentioned on this document. Thereafter, it is written in Bengali with regard to Shamol Sarkar's address. And thereafter, it is a declaration that I, Shamol Sarkar, but the English translation is at page 10.
Yes, got it.
Yes, my lord. My lord, thereafter, my lord will see from the page 9, it would be evident that the document, there were certain lines which were added in the middle, which is the second line. The father's name, that is Pita and the residence, that is the second line which was added. Subsequently, in the document, my lord, the handwriting is in normal course.
Yes.
There is with regard to the interpolation, I would come to question number 32. My lord, the relevant questions with regard to exhibit B is from 28 to 34.
Yes.
Of the chief, and the particular question which is most relevant is question 32 with regard to the interpolation. And the witness states that the word taka, which is written, was the only word which was rewritten. Apart from that, there is no other interpolation. There are, according from my personal view, my lord, there was this one line in the middle which is really close to one another. And apart from that, this is the only place where there is overwriting.
Correct.
At page 9. And my lord, the signature now with regard to question 31, again this receipt bears the signature of Shamol Sharkar, and the same signature on top of a stamp is appearing at page 9.
Yes.
And also very important is the second last line right after the word taka is the amount of 9,74,000. So this is also the entire amount is admitted. My lord will see at the second entry that is dated 15th of June 2009, page 3, paragraph 2 of the plaint. 9,74,000 is the amount in respect of which there is an admission. So my lord, this is the second document. Then the third entry is with regard to 1st of March 2010. This document is appearing at page 11.
That is exhibit B.
Yes, madam. So that is exhibit B. Exhibit C is a document, my lord,
Exhibit
which
B,
is a seizure list.
Exhibit B, but the exhibit B is subject to objection.
Yes, my lord, it is subject to objection.
Correct. Next.
My lord, next is a document which is indicated as 10A of the judge's brief. It is a seizure list because this particular document was seized by the Amher Street Police Station. My lord, I will skip that document and I will come to exhibit D, which is again a receipt, money receipt in respect of which the payment was made. And my lord, the seizure list was admitted at as exhibit C without any objection. The relevant questions are 35 to question 40. Now, my lord, the next relevant entry. If I may just quickly take my lord through the entries through which I have shown that I have made payment. The third entry is of 1st March 2010. And this document is appearing at page 11 of the judge's brief. The relevant questions are questions 41 to 47. And my lord, it was marked as exhibit D. Now, my lord, this document again, my lord, on 8th of December 2009, I had made the first tranche of payment. Again, on 15th, I had made further payment. Now, there is a gap, and on 1st of March 2010, I make another tranche of payment and I make a payment for a sum of rupees 25,000. Now, in the previous two documents, my lord, there is no real indication regarding the, my lord, sorry, my lord, I'll just take my lord back to page 9 and the translation at page 10. My lord, there is one indication that it was on urgent requirement for my business. My lord will see the third line at it was urgent requirement for business. Now, at page 11, my lord, is the first time which is where he indicates that this money is for the purpose of purchasing a motorcycle. My lord, the translation is at page 12. And my lord, there is also one more small entry, which is at the bottom right corner. There is 12/3/2010. Well, I show there's a 5,000 rupees.
Yes.
And for this particular document, the answer that has been given is that this is a money receipt, and it was written up. I had written up the money receipt, and it was read and signed by Shamol Sharkar on 1st March 2010. He had taken 25,000 to purchase the motorcycle, and again 5,000 more to prepare the papers. The entire document is written in my handwriting. This is the signature of the defendant, I know his signature. And in the contents, my lord, so 25,000 is admitted by way of this particular document. And a further sum of 5,000 is also indicated, but that is on a subsequent date. My lord, then may I come to the next document? That is at page 13 of the judge's brief. This is exhibit E. In the deposition, my lord, the relevant questions from questions 48 to 58. I will indicate that at question 48, it is incorrectly stated as appearing at page 12. It should be page 13. And the translated copy, my lord, in English is at page 14.
Yes.
And thereafter, my lord, this document is again, the loan was taken for the purpose of urgent requirement of my business. So he indicates that this is for the urgent requirement for his business. Question numbers 48 to 58 is what is relevant.
Yes.
And the only interpolation in this document is indicated at answer to question 54 is the name of the plaintiff himself.
Yes.
After the document, or rather at the time when this document was prepared, thereafter this name, it is hyphenated and then the name has been given. It is indicated at question 54. And a sum of rupees 30,000 and subsequently 15,000 was paid. This is what is, my lord, if I may only indicate, there's a 50,000 that has been indicated in this particular document. The document states at
15,000 or
50, 50.
But kindly come to the question 55.
Yes, my lord, I will indicate that. My lord will come to question 55. If amount of 50,000 has been indicated in the document. Now, my lord has seen that the plaintiff has indicated that a sum of rupees 30,000 and 15,000 was taken on 1st of March
and 10th of March.
And 10th of March. Thereafter, my lord would also recall that on 1st of March, there is a small inscription of 5,000 rupees at the corner.
That is exhibit C.
Exhibit
D.
If that is added to this, it amounts to 50,000. So, my lord, I will indicate, I have to be candid with my lord that this 50,000 would be inclusive of that 5,000 amount. And my lord will kindly come to the later part of the document, which is after the signature. And there is an admission that he will be making a payment of 4,800 rupees per month on account of a sum of rupees 80,000 that was due and payable between 1st of March and 10th of March. So, my lord, I am only trying to indicate that these were loans which were taken for separate purposes. Initially, he ran into some problem, and I will indicate from the depositions as well the nature or the purpose for which he had been taking this loan. Now we come to the final document with regard to the amount that was made over. It is at page 15 of the judge's brief of document. It was marked as annexure F. And my lord, the relevant questions are question numbers 59 to 66 from the deposition.
Yes.
Now, my lord, in the deposition, 59 to 66, there is, my lord, if I may read out My lord, would my lord prefer if I read out in vernacular, or should I read out from the English translation?
English translation.
English
It is there. I am
would
having
only
the original
indicate,
also.
my lord, this is 21st of March, the last payment, and on this last date of payment, the entire sum of 2,92,000, which is the admitted sum to have been received by him in tranches. The entire sum is reflected in one document. So the case of the defendant, where he has admitted to 2,92,000 being received, but he says it is in tranches. And my case is that I have made payments in tranches, and particularly this
Other than 292.
other than 292, and this 292 was paid at one go.
Correct.
On one particular date, which is 21st of March 2010.
Yes.
And not sometime in 2007. And my lord will also see that it has been the exact wording is labhangsho, which means share of profits, but it was meant to be payable as interest for 6% per annum. And one important thing, I shall pay the entire sum within 1 year. Otherwise, I will remain bound to give him the flat. So he had a flat in Belghoria, some Shri Krishnapoli. So he would be liable to give him make over that flat. So this is the last tranche of the agreement, and by way of these 5 documents,
yes,
the entire amount of 13,78,000 as indicated in the at paragraph 2 of the plaint is reflected that this amount was paid. My lord has indicated that I should go through the cross-examination with regard to the documents, but my lord had prepared on the first issue, which was with regard to the issue of cause of action and how the cause of action would arise within the jurisdiction. My lord, for the purpose of the cause of action, the relevant the paragraph 1 of the plaint and written statement, paragraph 7 is where the dispute has arisen. These are the relevant paragraphs. Thereafter, in the chief, question numbers 8, 9, 187 to 194, 205 to 6,
8,
205, 8 and 9. My lord, I'll just take my lord through the deposition quickly. My lord, question 8 and 9, which was at the on the second page, where is your place of business?
Yes, yes, I got
And
it.
he indicates that this is the place of business. In the plaint, it is incorrectly indicated as residence. So now he comes to the box and he indicates that this was actually his place of business. And to which address have you paid this amount to Mr. Sharkar? At the same address, 12/2. Also in the second document, which was at page 9, I had indicated that the address appearing on that document was also 12/2 Madan Mitra Lane, Kolkata. Now, at question 187 of the chief, this is dated 18th of February 2019.
Yes.
I am showing you a document disclosed at page 7 of the additional judges brief of documents. So, my lord, as I had indicated that there was an additional judges brief. And in the additional judges brief, a document which is an agreement has been disclosed. In that, alert, you will kindly see this is additional judges brief, page 7. This is the document. It is on a 10 rupee stamp paper, an agreement entered between Ashitendranath Mitra and Ajitendranath Mitra with the plaintiff. And my lord, additional judges brief of document. Page 7. Page 7.
Yes.
It would be a very old document.
This is the Bangla.
No, that is a different agreement. It is the additional judge's brief of document. My lord, may I make over my copy?
Yes, sir. It is there, I find.
Yes. My lord, there is one agreement.
You're getting
My
the
lord,
threatening.
One man army.
My lord, at questions 187 onwards, so this is an agreement which is indicated. The agreement was marked as Exhibit T. And my lord, the questions are from 187 to 194. 187. This is an agreement that I was a resident of 12/2 Madan Mitra Lane. For that purpose, it was procured from the landlord. The agreement was prepared from the landlord. The signatures of so and so are appearing. The signatures of their managers, namely Sarkar Babu, and his witness, namely Ashwin Kumar Pal, are appearing here. Yes, my signature is also appearing. And this was executed on 1st of October 1990. Then the witness encircles in red pencil and in blue pencil the respective signatures of the landlord and the witness.
Yes.
Thereafter, my lord.
This is Exhibit S.
Exhibit S. My lord, in the deposition is indicated as T, but very well, my lord.
T.
T.
Yes.
Now, my lord, so this is another relevant document which the witness comes up after the suit is filed. The witness brings this document to indicate that he was a resident of that particular area. Now, there is cross-examination on this line with regard to this particular document to challenge the cause of action. My lord, will come to page 200, question number 205.
Yes.
This is again an assertion that in his chief, I am 205, I am still in the chief. This is again an assertion that the loan was obtained from his office at 12/2 Madan Mitra Lane. Well, there is some problem that it has been continuously referred as residential and office, but it was actually his office. In cross-examination, that is clarified. So I will take my lord through the cross after this, and all the loans were paid from 12/2. Then, my lord, again at page question number 221, he indicates that 12/2 Madan. This is again in his chief. He indicates that from 12/2 Madan Mitra Lane, he was carrying on paper business for paper supply. In paper supply from 12/2 Madan Mitra Lane. And thereafter at 280. This is very relevant. That so is it your evidence that the office of Maiti supplier is not situated at 12/2 Madan Mitra Lane, and it is that premises you only keep paper and paper of the business. Is that so? No, I have a office premises at premises number 12/1. It should have been had, but he had the business the office premises at 12/1 Modern Mitra Lane, and I also used to reside there. So my lord,
So it is 12/1.
so 12, no, my lord will kindly see that he was carrying on business from 12/2. And this 12/1 in respect of which the agreement is indicated.
No, where from you getting 12/2? I have office at premises 12/1. Kindly come to the
My lord
280.
my lord will take 276 as well. I take it your evidence is that you run your business from 12/2 Modern Mitra Lane. Is that is it so? That is so. So he is running his business from 12/2.
But kindly come to the 280 again.
280. No, I have the office premises at 12/1 Modern Mitra Lane. I should reside there too. So my lord, the question was 12/2. The answer should have also been 12/2. So he was residing at his own office as well, which is why he uses to state it as his residence in the plaint, which was the incorrect statement. But then apart from that, the office of
No,
mine.
no, what about the 12/1?
Well, this has gone in incorrectly, my lord. The question indicates 12/2, but the answer by mistake
There's a
typographical error, my lord. And what was the actual position is that he used to reside in his office, is why he calls it his residence as well. This particular office was used to store his papers. So, my lord, this is the extent of the chief and cross in respect of the issue with regard to jurisdiction. If my lord permits, then I will come back on the next day and indicate with regard.
Do one thing, you come with next day along with your written notes
of argument
can be completed. Only with regard to the, this is with regard to the cause of action, now only with regard to the fraud and forgery.
My lord, there are two more issues I will indicate. As I had shown the respective receipts, so these receipts will come in. There is one more agreement, my lord. My lord, only if my lord takes up the judges, additional judges brief once, my lord, there is a handwritten agreement from page 1.
Yes.
And 2. My lord, what had happened is that this agreement, in this agreement, there was 13,78,000 which was made over initially. Then there were certain police complaints which were filed. Initially, 2 tranches of payment was made by the defendant. Police complaints filed. Subsequently, 2 more tranches payment came in. After that, the plaintiff pursued the defendant. The plaintiff went to the residence of the defendant. Certain disputes arose between the parties, and at that point of time, this agreement was entered into with the locals in that particular area, where the defendant has admitted that he will be making payment of 8 lakhs 47,000 within a certain period, and he would also be making monthly payments of 12,000 per month. So this agreement would be necessary to.
That is not your case.
My lord, I am claiming the entire amount because he did not subsequently make payment. So apart from the admission of 292, there is also an admission of 8 lakhs 47 by the defendant. This document.
What is the total claim?
My total claim is 14 lakhs. 14 lakhs 82,000. So that is on the basis of the original transaction.
Yes, original transaction along with the interest, 6%.
But I will only need to place this document. This is the document which has been disputed. The defendant has come forward during his cross-examination. If my lord takes up the cross-examination, he has come forward and tried to show that it is not, you could not have claimed 1378 or 12 lakh 72 on account of the adjustment. You could not have claimed 12 lakh 72. You ought to have claimed only up to 8 lakhs 47. So this is also a false case.
So who has brought this document? You.
I have brought this document as in order to show an admission by him that this was subsequently also executed.
So if it is admission, then why not 13 lakh? Why it's 8 lakhs only?
My lord, at that point of time, because in order to get back that money, and there was a admission
And you
that he would be
admitted,
making
you
12.
admitted the 8 lakhs on that time at that point of time.
No, I did not forego, my lord. So there are because my lord, initially, if it is like a one-time settlement, there is an amount which is due and payable. If that person is not making that payment, then at least give this amount and give it to me in tranches. It was an attempt at amicable settlement. This issue I will have to deal with, my. But since the plaintiff did not go ahead, the defendant did not go ahead and make payment, this becomes infructuous, and I go back to my claim of 13 lakhs.
And in the suit, they are claiming, they are admitting only 292.
Only 292. They have not even indicated this document.
Okay.
My lord will give me 1 hour's time. Any other date, I'll
For
finish.
the plaintiff, you come with the written notes of argument.
Yes, I'll come with it.
Counsel for the plaintiff is present along with none appears on behalf of the defendant. Counsel for the plaintiff has argued at length and prayed, argued at length, but prayed for time. And prayed for time. Full stop. Let the matter appear on on 19 July at 3 p.m.
Much obliged, my lord.
Next. The matter was listed on 17 February 2023, but none appears on behalf of the petitioner. And none appears on behalf of either of the parties. And for the interest of justice, the case was adjourned till 2nd March 2023. At the time of passing of the order dated 17 January 2023, it was specified that in case none appears on behalf of the plaintiff, appropriate order will be passed. Today also, when the matter is called, none appears on behalf of the plaintiff, no accommodation is sought for. It is fine from the record. The plaintiff is not interested to proceed with the matter. Accordingly, CS 14 of 2015 is dismissed for default. Interim order, if any, stand vacated. Next.
21.
Same order, dismiss for default.
22.
Yes. 22.
23, 23 and 24.
22, same order, dismiss for default.
Twenty-three,
Okay,
I am for the
23.
plaintiff executor. My lord, we have given our suggested issues. Now it is for them, my lord, as per the last order of your lordships. In March 31, they were given 1 week time to file their suggested issue as a last chance.
You'll kindly have a look at the order.
Yes, you are for the
Defendant lordship.
Caveat.
I have
Caveat
my
is-
suggested issues ready with me right now. There's an application that I have filed for amendment that's coming up on Wednesday. This
what amendment? Plaint.
No, my affidavit of assets.
Affidavit assets, the affidavit assets request to be amended. 2 of the properties are my properties which have been included. So that whatever it is, lordship.
That is his
Yes, that's
contention.
my contention. That is coming up on Wednesday, day after tomorrow. I'll only request my suggested issue is ready with me, but I do not wish to file it today. As soon as I move that application, I'll file it there and there. Day after tomorrow, Lordship.
With regard, letters should go with regard to that.
I'll tell you why, Lordship, because this I have also made an issue in there. Lordship will kindly have a look at the issues. I'll just indicate the issue number. I've also, it's a.
What is the issue?
Normally, the contents of the affidavit of assets should not be the issue. The probate
That
court is
is-
concerned with the
That is
execution.
that
and
is
the-
why I'm saying, Lordship, I have the issues ready, Lordship, but I like to move that application first and thereafter file the suggested issues. That's coming up day after tomorrow, Lordship.
March 31 order, they were given
Yes,
1
I
week's
have.
time.
I have it here,
Last
Lordship.
chance. So
Lordship
then
will kindly record that
the
I have it.
application is filed much later, when after the time expired.
Counsel for the respective parties are present. Full stop. Counsel for the defendant submits that he has filed an application being GA number
5, Lordship.
5 of 2023, praying for amendment in the affidavit of assets and read that the said and submit that the said application will be listed on Wednesday.
Yes, that is on the date.
On 17th May 2023.
Day after tomorrow.
Full stop. Counsel for the defendant submit that let this should be listed on 17th May 2023.
Along with GA5.
2023. In view of the submission made by the counsel for the defendant, let CS number 23 of 2016 be listed on 17th May 2023 along with GA5 of 2023. Next.
In the next matter, my lord, similarly, I am for the plaintiff executor. Here, my lord, I am seeking extension of time for both parties as in fact seeking extension of time for completing the directions given in the order dated 8 February.
2016 matter.
Yes, my lord, there are 2016, my lord, there are many old documents. Now we are trying to come up and so that, my lord, the judge's brief while taking steps to prepare, my lord, many documents have come to our notice.
What is the order?
So kindly give me 4 weeks.
6 weeks.
Kindly give me 6 weeks time.
You are appearing for the defendant.
Kindly give me 6 weeks time to complete the directions given in the earlier order.
Counsel for the respective parties prays for extension of time to complete the discovery and inspection of the documents.
Mala, it's a prayer made by both sides.
Considering submission made by the counsel for the respective parties, what?
Prays for extension of time to
Complete the discovery and inspection of the document. Full stop. Full stop. Considering the submission made by the respective parties, time to complete the discovery and inspection is extended
By
for
6 weeks, my lord. 2 weeks holiday, my lord.
for a further period of
We will not be here, my lord.
for a further period of 4 weeks from the date of reopening of the court after
yeah.
summer vacation. Full stop. The parties are also directed to file their suggested issues in the meantime. Let the matter appear on 5th July 2023 for framing of issues.
Lordship. Grateful, ma'am.
No, Jeet Kaur.
Later.
Yes, my lord, I am for the plaintiff.
Yes.
My lord, it's an application, my lord, for grant of letters of administration with the will annexed.
Page number, item number,
Item 25, my lord.
testamentary suit.
Yes, my lord.
Yes.
It has been converted into a testament.
Yes.
Which
I'm
the
for
other side?
one of the defendants, brother.
Ah.
In this matter.
So
I
what is
think
the stage now?
there are 2 interlocutory applications which is appearing in your lordship's list after quite some time.
Yes.
I think GA.
And my lord, one of the, I have been recently inducted. The only difficulty is, my lord, one of the beneficiary, Mr. Karan Paul, my lord, his mother had expired last month. My lord, since this is an old matter which has come up in your lordship's list, my lord, if we, my lord, come back after vacation, then, my lord, we will be able to assist your lordship better. My lord.
Where is the GA? GA is there. So GA pleadings completed.
GA, my lord, as far as GA,
one old GA 1171 of 2017 is concerned, but I find that pleadings have been completed in that matter.
Yes. What is for GA?
That is a GA for some corrections in the order.
Corrections in the order.
Yes, corrections in an earlier order passed in this testamentary suit. And since it was not a mere arithmetical or a inadvertent mistake, lordships had on the earlier occasion directed that there should be yes, not your lordship's code. So since my learned senior friend has already said that he is not prepared, I shall indicate that perhaps
as per the order passed by this court dated 6th January 2020, the matter was fixed for passing judgment, reserved for judgment.
Reserve for judgment.
Reserve for judgment, Milord, is maybe some other GA.
GA 1839.
That was disposed
of. GA 1839 has been disposed of pursuant to the judgment dated December 16, 2020.
What order was passed?
But that is not appearing in a lordship's list today.
No,
that is not.
What was the order in that?
117.
It should appear before Justice Tanda. You have the brief. The order is at page 97.
Yes. So who has passed the order? Against whose order you wanted?
Yes,
to
Milord. Now this application which has been taken.
I'll just indicate to your lordship, if lordship kindly takes the master summons prayer A.
Master summon of
GA 1171 of 2017.
That is new GA 5.
Yes. Yes.
This is for correction of the order dated 7th February 2017 passed in GA 1188 of 2016. Now, if lordship sees the order is appearing at page 97 of the application, which has been passed by Justice Tandon in this matter.
So it has to be taken.
Yes.
Yes, it has go before.
But you have to tell who has filed this application.
This application is filed by the applicant, the propounder.
Yes, we have filed the application, but it was filed in 2017.
Application for assignment.
Yes, the
lordship expresses that within lordship's order, that would, I think, facilitate the entire.
But not the division when the Justice Tandon is not
Justice
sitting
Tandon
here.
We will have to go and mention before the division bench taking leave from the other judge. If Justice Tandon sits in a single bench, then this matter can be heard.
Correct.
That is the procedure. Yes.
You have to mention before the judge.
Yes, but
your lordship will release this matter, your lordship.
Give that file. No.
Only this application. Let the main suit remain before your lordship. Only this application, because
not here, but it is listed. It's listed.
May I hand over our copy?
That is not before this court.
Yes, it's there. I can hand up your a copy of the application.
Give it.
Page 97 तक है to mark कर दें.
Counsel for the respective parties are present. Full stop. The plaintiff has filed an application being GA 1171 of 2017, praying for correction of the order passed by His Lordship Justice Harish Tandon, dated this order is passed in 1188.
Yes.
97.
Yes.
Yes.
And you have prayed for correction, Achavan.
In a separate G.
Because 7th February 2017 order disposes of that application.
An application of 1171 of 2017. Correction of lordship.
Justice Harish Tandon in GA number 1188 of 2016 in connection with PLA 263 of 2011. Full stop. As His Lordship is available, and as such, the GA number 1171 of 2017 is released from the list of this court with the liberty to the counsel for the petitioner to approach before his lordship for listing the matter.
Great.
Public.
Well, the main testamentary suit made appear in the monthly list of June
As
2023.
regard the testamentary suit number 8 of 2017 be listed in the combined monthly list of June 2023.
Great.
Lord, may I take back my brief? Please? Deeply obliged.
Take back these or order also.
My lord, I am for the defendant. Some talks of settlement is going on, and you'll kindly keep the matter after vacation.
What settlement?
My lord, actually, I am on
As per the prayer made by the counsel for the plaintiff.
defendant.
As per the prayer made, it is indicated none appears on behalf of the plaintiff. Full stop. Counsel for the defendant is present and submits that a talk of settlement is going on and prays for time. In view of the submission made by the counsel for the plaintiff defendant, let the matter appear in the combined monthly list of 2016 and June 2016. June 2023. Sorry.
Gratitude.
I appeared on behalf of the defendant.
Yes.
There was an earlier order, none appeared on behalf of the plaintiff. So on 17th of February, let it be dismissed for the time being.
Same order as dismissal, but record. So and so appearing for the defendant. None appears for the plaintiff. The matter was listed on 17th February 2023, but none appears on behalf of the plaintiff. And accordingly, for the interest of justice, the case was adjourned with the rider that in case none appears on behalf of the plaintiff, appropriate order will be passed. Today also, when the matter is listed today, none appears on behalf of the plaintiff, no accommodation is sought for. It reveals from record the plaintiff is not interested to proceed with the matter. Accordingly, TS number 3 of 2018 is dismissed for default. Interim order, if any, stand vacated.
Obliged.
Next.
Appearing for the petitioner, my lord. Here, my lord, the original defendant passed away. We have made the amendment of the petition, incorporating the name of his two sons.
That is listed.
My lord.
J is listed.
No, my lord, it's over, my lord. My lord has passed the order. We have carried out the amendment, my lord. We have served the copy to the address provided by the advocate on record. They are not staying there. Then, my lord, we have found that some other address, my lord, we have served there also. The packet came as left.
Where is your affidavit of service?
My lord, just today, my lord, I have received those packets, my lord. Let the matter be kept tomorrow, my lord. I'll show the affidavit of service, and my lord can.
Okay, not today.
My lord.
Not today.
Lordship, I am from the plaintiff. The advocate is not coming to court today due to some personal difficulty. Praying for not today.
Not today. What will happen tomorrow? Last occasion also 2 weeks time was granted. Prior date also none appears on the plaintiff. No steps has been taken. Issues have been framed. No documents are disclosed since 2019. As per the prayer made by the proxy counsel, the case is adjourned for a day. Let the matter appear tomorrow. It is made clear that if no steps has been taken by tomorrow, appropriate order will be passed. Next,
No, I am for the plaintiff, my lord.
yes.
Well, possibly, my lord, there is a, we have talked together because it is a testamentary suit. My lord, we have talked together that in the sense that we will disclose the documents, whatever is there further by tomorrow. And my lord, so far issues are concerned, I will exchange the issue, my issue, and they will exchange their issue. And my lord will kindly fix any day for the hearing because we will prepare the judges before documents also. And your lordship will have to frame the issues.
February 2020, inspection was ordered.
No, my lord, further order was there, 2021 also.
Then you are not completed.
Has not been totally completed, my lord. There's one or two documents are there today, by today, tomorrow will be.
One or two documents, if they want to rely, they can give us.
I will give it. I will give it. And my lord, we will exchange our.
Counsel for the respective parties are present. So counsel for the plaintiff.
I am from the plaintiff.
Counsel for the plaintiff that though the inspection has been given, but further 2 or 3 documents is required to be given for inspection, and the same will be provided within 2 days. And prayed for extension of time for 2 days for offering the further 2/3 documents for inspection. In view of the submission made by the counsel for the plaintiff is directed to offer the inspection of the document, if any, within 2 days from date. In the meantime, the parties are also directed to exchange their suggested issues. List the matter on 7th June 2023 for framing of issues.
Extremely grateful, my lord. 7th June, my lord. Grateful.
Next.
My lord, Anjana Banerjee is appearing for the petitioner. I am on her behalf. I am praying for not today.
Why? Last occasion also, 13 February also, the case was adjourned.
My lord, during her personal difficulties, he has just left from the court.
So what can be done tomorrow?
Tomorrow.
What is the stage? What is the stage of the suit? Not today.
Grateful, my lord.
My lord, I am appearing for the caveated defendant. My lord, lordship would see, my lord, the last order of 9th of February 2023. My lord, they did not appear.
None appears for the plaintiff.
Lordship, I appear for the plaintiff.
Counsel for the defendant, although those received the affidavit, but the affidavit does not contain any document. Yes.
Lordship, by an order dated 3rd September 2022, directions were given for discovery and inspection. Lord, we have done our discovery and inspection. We have forwarded them a copy of the affidavit documents. Till today, my lord, they have not filed the affidavit documents.
No, my objection is that the affidavit of documents have been given, but the documents have not been
Lord, if
disclosed.
the lordship kindly takes order 11 rule 21.
Yes.
Non-compliance with the order for discovery. What will happen if they does not disclose? Lord, is it a case, my lord, that they will see my documents and they will prepare their affidavits of documents?
No, my lord, before my
That is
lord,
not the procedure.
going to the subsequent rule,
Lord,
if
if
lordship would
lordship
kindly take the
takes order 11
previous rule,
rule.
order 11, rule 13.
Lord, may I just place the provision?
Yes.
Lord, non-compliance with order of discovery. Where any party fails to comply with any order to answer interrogatories or for discovery or inspection of documents, he shall, if a plaintiff, be liable to have his suit dismissed for want of prosecution, and if a defendant, to have his defense, if any, struck out, and to be placed in the same position as if he had not defended. And party interrogating or seeking discovery or inspection may apply to the court for an order to that effect. An order may be made on such application accordingly. So, my lord, today, my lord, he has not filed his affidavit document in spite of my giving him notice that kindly take my inspection. They have not even taken inspection.
That's why.
Well, if my learned friend is taking shelter under order 11, rule 21, then my lord, the first slim says that the By non-compliance of the order, the plaintiff's suit shall be dismissed.
Their case is that you have submitted the document.
Lord, in our original side rules, my lord, the affidavit documents does not contain the affidavit, my lord, the documents. It has to be in the judge's brief of documents.
Yes, so whether the document has been given inspection for him.
My lord, we have requested, they have not taken.
No, my lord, in the affidavit of documents of lordship.
It will not be there. That is not the procedure.
Whether any, and you have prayed for inspection of the document.
I'm sorry, my lord.
Have you prayed for the inspection of the document, requested for inspection?
No, my lord, but my lord, we have requested
Where?
for
When?
giving, my lord, on 23rd of December 2020.
Then?
My lord,
When-
he
when you
requested,
requested?
my lord, he requested for the copy of the documents. My lord, under the procedure, my lord, he is supposed to get the documents in the time of, my lord, the judge's brief of documents.
Yes, lordship, kindly see, my lord, order 11, my lord, rule 13, my lord, read with, my lord, appendix C, form number 5.
Yes.
Yes, my lord, kindly see form number 5. I have in my possession or power the documents relating to the matters in question in this suit set forth in the first and second part of the first schedule. Now, my lord, lordship will kindly see the affidavit of documents filed by my learned friend. My lord, page 3.
Where is the affidavit document?
My lord, where does the rule provide that I have to give the documents in these affidavit documents?
Where is the affidavit document?
Lordship, I had filed, my lord.
My lord, maybe hand over hard copy, my lord.
Yes.
Yes, kindly see page 3, my lord.
Yes.
Confidential communication. And my lord, this is going on since December 2020.
Okay. Then what do you want?
But if he discloses his documents, I'll take inspection.
I am fixing a date.
Lordship.
Let you offer the document.
Lordship.
Let you complete the inspection.
Lordship.
Leave aside all the.
My lord, prior to that, he has
Legal-
to file his affidavit documents. Then only he will be
filed.
Lord, he
No,
has
I have not filed.
Why?
Lord, he is taking that shelter.
Why you not filed? You also filed. You give the inspection. You will give the inspection.
He will
then
give the documents. I will prepare the judge's brief. That is the procedure, not on side rules.
You also not given that.
This is
But I-
unheard, something unheard.
My lord, if I do not disclose my documents, then my lord, the suit can proceed on the basis of the disclosures made by my learned friend.
If you will say you are not
Absolutely, I am
intending to
grateful.
file the document, then I will record that.
I will get.
If you will say you are relying upon the document, then you give the document and affidavit. He will give inspection will be completed. Then he will file the judge's brief of document. and the
Absolutely.
case will
Yes, my lord, I'll disclose my documents within the next 7 days.
I am grateful.
And he will offer the document
Yes.
for inspection within 7 days.
Lordship.
Correct.
Yes, my lord.
After completion of the inspection, he will file the judge's brief of document. In the meantime, the suggested issues may be
Yes,
exchanged.
my lord.
Counsel for the respective parties are present. Full stop. The counsel for the defendant submitted. He will disclose the document by way of an affidavit within 7 days from date. Full stop. The plaintiff, counsel for the plaintiff submitted. He will offer the document for inspection within 7 days from date. Full stop. In view of the submission made by the counsel for the respective parties, let the inspection of the document may be completed within a week from date. Full stop. In the full stop, the parties are also directed to exchange their suggested issues. In the meantime, let the matter appear on
Lord, instead of 1 week,
2 weeks.
because it will be a holiday, my lord, of the next week.
Okay, let be complete. 1 week, 1 week, na? 1 week after the summer
Lordship,
vacation.
Lordship.
1 week after the summer vacation. Full stop. Let the matter appear on 20th June 2020
I'm grateful.
My
for
lord,
framing of issues.
my lord, item number 54 is fixed today, your lordship, at 3 p.m. I am being led by Mr. Shoboshaji Chaudhary, your lordship. He is not in station this week. Seeking an adjournment for the day, if your lordship could give
It's
a
for
date.
the other side.
My rank.
I have notified my lord. He's here.
No problem.
Any date if your lordship fixes after
Item
vacation.
number 54. Counsel for the respective parties are present. The matter is fixed today at 3 p.m. for hearing, but due to personal difficulties of the learned counsel for the plaintiff,
Petitioner,
counsel
your
for the petitioner, the matter could not be taken up for hearing. Accordingly, the case is adjourned Let the matter appear on 20 July at 2 p.m. 12 noon.
Grateful.
July 20.
Grateful.
20 July at 2 p.m. and 12 noon.
My lord, item number 33, my lord.
Ah.
My lord, I believe this was, my lord, the last order says that this was, my lord, inspection and my lord, discovery were to be completed. Issues were framed on the last date. Now, my lord, since the matter is was to appear, my lord, in somewhere in March, but it didn't for some reason, my lord. I was only praying that witness action be kept, my lord, post vacation anytime. Mr. Ghosh is, my lord, leading me in this matter.
My lord,
But my judge's brief of documents and other documents which were, my lord, supposed to be made ready are all prepared.
my lord, I have to submit something. My lord, on 1st of February, my lord have framed the issues. My lord directed for filing the judge's brief of documents. My lord, thereafter on 28th, they have filed. They have given us a letter. They giving that they will adduce further evidence, or they want to disclose further documents. We have not taken inspection of those documents, my lord, as on date, because first they have come up on 1st of April, I think on 4th of January, they have come up with an application stating that they want to give further documents in this matter. We have taken
Is there
inspection.
any application which filed for additional document?
I believe
No.
so, my lord.
Perhaps, my lord, I am not too sure though, my lord, but even
Well,
if
this is
there
the second
Now
time.
what is your prayer now?
my lord, I was saying, my lord, if your lordship, my lord, fixes it after the vacation, my lord, for
No,
inspection.
I will inspection. I will.
Not
I
for
will fix.
inspection.
I will fix for the witness action. In the meantime, if
In
you
the
want to-
witness action,
My lord, no
meantime,
judges.
if he wants, so wants, my lord, he
you
can
cannot
take
file the
inspection.
judge brief document, witness action. What will be have? What
No,
will
there's a
happen?
judge's brief of documents and there's a further judge's brief of
My lord,
documents.
my only prayer is they will not be allowed to include that document with the judge's brief of
That
documents.
is unless and until they will pray for. That cannot be.
He wants to take inspection in the meantime.
Counsel for the
he
respective
might
parties
take
are present.
inspection.
It is fine from the record. The issues have been framed, but issues have been framed, and there was a direction upon the plaintiff to file judge's brief of document, but no judge's brief of document is filed. In view of the above, the plaintiff is directed to file the judge's brief of document within 4 weeks from date. Let the matter appear on 20 July at 2 p.m. for witness action on behalf of the plaintiff.
My lord.
Come on that day.
Lord, I beg to appear on behalf of the defendant, my lord.
I'm for the plaintiff and I'm led by Mr. Dartmouth.
Lord, I'm led by Mr. Thakkar, my lord. I've been told he's on his way, my lord. May I start? Lord, this is a suit for recovery of money filed by the plaintiff against the sole defendant, my lord. The allegation in the suit is that there was money lent in advance to the defendant, which the defendant has not paid, demand notice issued, and as such the suit. My lord, in the suit, there are two applications. The first application being GA1 is an application by the plaintiff for judgment upon admission. The pleadings are completed in that application. The second application has been taken out by the defendant for addition of proper and necessary parties, my lord. In that application also, the pleadings were completed. The second application is what your lordship was hearing on the last occasion and has been fixed for us to complete our submissions before the
Addition of parties.
Yes, on the addition of parties. My lord, this is a situation which is not a simpliciter situation of recovery of money lent in advance, my lord. But there is a transaction which has resulted into the suit being filed against the defendant, my lord. And our statements are that this particular transaction has to be looked into in its entirety before any orders could be passed. And there are certain parties which, according to us, are proper and necessary parties without whose presence this suit cannot be adjudicated in a proper and necessary manner. My lord, our endeavor today would be to assist your lordship with regards to our application as to how the parties that we seek to add in the present application are relevant for the proceedings to be commenced and proceeded against the defendant. Now, if your lordship takes my application under GA2, my lord, at paragraph 22 at page 12, we set out the persons who we seek to add. My lord, the first being one Raju Patni, the second being a company which is Sagittarian Credit Capital Private Limited. The third is Pranava Electronics Private Limited, which we say is a sister concern of the plaintiff company. And my lord, the fourth is Mr. K.R. Pradeep. My lord, so what actually transpired with regards to the money that has been sought for recovery by the plaintiff from the defendants, my lord? This was a transaction where admittedly money has been advanced to the defendant to a tune of rupees 3 crores, my lord. My lord, it's the specific case of the defendant that the money that was given to the defendant was given in a manner that the defendant was made a conduit to assist the transfer of money from the plaintiff company to its sister concern company, my lord. My lord, it was a 4-level transaction, my lord. My lord, the first being the plaintiff who transfers the 3 crores to the defendant who is an NBFC on an agreement that the money would bear 9% interest. And it was agreed between the parties, which we say was agreed between the parties, that the defendant being an NBFC will loan and advance the same amount of money to this entity called Sagittarian. And thereafter, Sagittarian would send this money back to Pranava Electronics, which we say is a sister concern company of the plaintiff entity. My lord, so what could not have been done directly has been sought to be done indirectly by the...
Who has taken loan from the plaintiff?
The defendant. The defendant has taken 3 crore rupees.
3 crore rupees.
Yes.
And defendant and they asking for the recovery from the defendant.
Yes.
So you have made out the case, you have obtained the loan and you have given this.
Yes, ma'am.
Correct.
Yes.
You have not made a claim against them.
Yes.
You have not made a claim.
My lord, that is, we have not filed a written statement, my lord. We have to file a written statement and we have a counterclaim, my lord. Because once till the time the written statement cannot be on record as on date, that is a statement that I can only make from the bar, because there is a counterclaim against the plaintiff entity with regards to 2 to 3 aspects which would be called out in our written statement along with a counterclaim, my lord. So there in fact would be a counterclaim that the defendant is making, my lord, because
if this person will be made as a party,
Yes.
what would be the cause of action against them?
My lord, that is the exact position where I come on from, my lord. My lord, in the counterclaim, as has been established, a counterclaim is a plaint in itself, my lord. It's an independent proceedings, one that is filed within the ambit of the plaint, because there's something that is to be adjudicated together with the plaint, my lord. But the moment the counterclaim comes on board, that counterclaim shall not be and cannot be with the plaint adjudicated without the proper and necessary parties to be added. Not because till the time we cannot establish as to what one, our counterclaim is, and two, the defense that we sought to establish. Not because the plaintiff has sought to make out a case that's a clear and simple transfer of money and recovery of the same. But the transaction made by the plaintiff was made on certain pretexts, which has to be understood before it can before the court can come to a conclusion that whether it was a simpliciter money, is it a simpliciter money lent and advanced to the defendant, or whether there are certain promises which were made along with the money that was advanced to the defendant company, Lord. That is the endeavor that we seek to have today, Lord. Lord, I'm led by Mr. Thakkar. If I
yes, no problem.
Lord, I'm told your lordship inquired before. I'm sorry, my lord, for being late. Your lordship inquired whether I have a claim against any of the parties whom I propose to add. My lord, that claim which I have against those parties, my lord, cannot be made the subject matter of this suit, because a defendant cannot claim against another defendant. Correct. But for the basis of my counterclaim against the plaintiff, my lord, these parties whom I propose to add are necessary, are proper parties, because these are parties in whose absence, in my contention, my counterclaim cannot proceed. Because when your lordship sees, there are two aspects of the matter. One is, as far as the plaint case is concerned, it is the choice of the plaintiff. The plaintiff is dominus litis as to whom it should include, whom it should not include. To that, there is one exception, my lord, in Order 1, Rule 10, under which I have applied, that the court may on its own motion also add a party whom the court thinks presence is necessary for effective adjudication of the issues involved in the application. Now, my lord, by way of my present application, I have brought before this honorable court the facts in which to persuade your lordship that the presence of these parties is necessary to determine the list as claimed by the plaintiff. That is one leg of my submission, my lord. The second leg of my submission is this, my lord, that I have a counterclaim against the plaintiff also. Now, as a counterclaimant against the plaintiff, my position is that as if I am the plaintiff in the counterclaim. Correct. Now, when I agitate my counterclaim, my lord, I am entitled to seek addition of parties in this suit whose presence is necessary for determination of my counterclaim also. So I have therefore two limbs of argument. Yes. Now, my lord, as far as my argument on the first limb is concerned, my lord, that in spite of the plaintiff being dominus litis, it is always open to the court to direct addition of party if the court is satisfied that the presence, because that is a situation which is squarely contemplated in Order 1, Rule 10, my lord. May I just for 1 second place Order 1, Rule 10, please, my lord.
Yes.
Kindly have Order 1, Rule 10, Sub-Rule 2, please, my lord.
Yes.
The court may, at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any improperly joined, whether as plaintiff or defendant, be struck out. This I'm not concerned with. And that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit, be added. So, my lord, it's either upon or without the application of either party. So your lordship can do suo moto also. Here I have applied. And before that, my lord, at any stage of the proceedings, I have applied at the very outset. There is no delay on my part, my lord, which will prejudice the trial of this suit. Third, my lord, whether as plaintiff or name of any person who ought to have been joined, whether as plaintiff or defendant. So, my lord, a person who is directly involved in the relief which is claimed, whether as plaintiff or as defendant.
or whose presence before the court may be necessary in order to enable. Now, this is where I beseech your lordship. The presence of these parties is necessary in order to enable the court to effectually and completely adjudicate upon and settle all the questions. That is, the persons whom I am seeking addition of, my lord, are proper parties whose presence is effectually and completely required. These are not parties against whom any relief is claimed. That is the limb which is covered here, my lord, by the third limb. After plaintiff or defendant, presence is necessary in order to enable the court to effectively and complete. So although no relief may be claimed, my lord, either of the parties can apply to the court, or the court may on its own motion direct addition of party. Now, my lord, the parties, again, for whom I seek addition of, are summed up in paragraph 22 of my application. My lord, this I am just pressing on the first limb of my argument, my lord. Paragraph 21, your lordship kindly has at page 12, please, my lord. And then I'll explain the role played by each of these persons, my lord, in the transaction between the parties.
Yes.
In the facts and circumstances stated above, Mr. Raju Patni, Sagittarian, Pranava Electronics Private Limited, and Mr. K.R. Pradeep are necessary parties whose presence is required for the adjudication of the issues involved in the above suit. The presence of these persons and entities is necessary in order to enable this honorable court to effectually adjudicate upon and settle all the questions involved in the suit. Non-implement of these persons and entities would lead to multiplicity of proceedings.
Yes.
Now, my lord, I have named the persons Raju Patni, Sagittarians, Pranava Electronic, and K.R. Pradeep. Now, my lord, may I start from serial 4 first, please, my lord, which is Mr. K.R. Pradeep. My lord, Mr. K.R. Pradeep was the promoter director of the plaintiff at the material time. He is one, and perhaps he was the managing director, if I am not wrong, of the plaintiff at the material time when the transactions took place between the parties. He is no longer, my lord, in control of the plaintiff, but at the material time, he was in control of the plaintiff company. My lord, Pranava Electronics Private Limited, as the name itself would suggest, my lord, was also under the control and ownership of Mr. K.R. Pradeep, and is an associate company of the plaintiff, my lord.
Yes.
Then, my lord, Sagittarians Credit Capital Private Limited is a company owned and controlled by Mr. Raju Patni. This person described in serial 1. Now, my lord, why I say
these the 1 and 2 is connected?
1 and 2 are connected, 3 and 4 are connected, and 3 and 4 are both connected to the plaintiff. 4 being the person.
Okay, 3 and 4 you stated that, but how the 1 and 2?
1 and 2 are, how are they connected to the plaintiff? Yes, that is by way of the transaction between the parties that I'll just briefly give an explanation, briefly give your lordship the overview, and I'll show you the document in this regard, my lord. The transaction between the parties, my lord, is summed up in paragraph 6 to 8 of my application. 6 to 8 and then 9. Six to 8, 9 and 10, in fact, my lord.
Yes.
Now, my lord, the transaction between the parties was such. My lord, Mr. Raju Patni approached the director of the applicant before your lordship, my lord, the director of the defendant, Mr. Sanjeev Bhupna, and represented that, my lord, the party number 3, my lord, that is Pranava Electronics Private Limited, had advanced huge loans to Sagittarian, that is his company. Now, my lord, Pranava Electronics Private Limited wanted to reduce its exposure to one entity because the banks from whom Pranava had obtained credit were raising objections as to why has one entity, that is Sagittarians, being advanced such huge loans. So it wanted to reduce its exposure to Sagittarians, that is Pranava Electronics.
Correct.
So, my lord, the scheme that was devised was that the plaintiff company, my lord, Pranava City Complex Private Limited, would lend and advance funds to the defendant, which the defendant would receive and act as a conduit and pass on to Sagittarian. And with the funds which Sagittarian would get, it would repay the advances of Pranava Electronics Private Limited. So it was a circuitous transaction, my lord, between these two entities of Mr. Pradeep. Two entities being, my lord, the plaintiff would advance money to me, which I would give to, my lord, his other, which I would give to Sagittarian, which Sagittarian would onward pay to Pranava Electronics. So from one hand of the plaintiff, money is going into the other pocket of the plaintiff, the money is coming. And it is the plaintiff's own fund. I have nothing to do in this regard, my lord. For this conduit facility, which I was providing, my lord, I was supposed to get 2%, my lord, of the charges as facilitation charges. That I have pleaded here. All this was done, my lord, that these facts would be evident from the conduct of the parties, my lord, which I have specifically pleaded in paragraph 10. Now, my lord, may I place paragraph 10? In pursuance and on the basis of the aforesaid tripartite agreement, the plaintiff made online transfer of rupees 2 crores on 12th March 2018 and further rupees 1 crore on 13th March 2018 to the petitioner. On 22nd March 2018, the petitioner transferred rupees 3.15 crores to Sagittarian. Out of the said sum of rupees 3.15 crores, rupees 15 lakhs was paid to Sagittarian towards repayment of a previous loan. The petitioner was informed by Mr. Patni that on 12th March 2018 and 13th March 2018, Sagittarian transferred an aggregate amount of rupees 3 crores to Pranava Electronic Private Limited. All the aforesaid transfers of amounts were shown on paper as loan transaction, but were actually circular transaction. The amount transferred by the plaintiff was shown as a loan carrying interest at the rate of 9% per annum, and the amount transferred by the plaintiff by the petitioner to Sagittarian was shown as loan carrying interest at the rate of 11% per annum. No document or loan agreement or any bill of exchange recording the aforesaid tripartite agreement was executed. Now, very important, nor was any document executed in respect of the aforesaid transactions of fund transfer. So, my lord, in this actual transaction was not documented, neither the transaction on the basis of which the plaintiff has sued. The plaintiff claims that it has lent and advanced monies to me. These are transactions between two corporate entities. There is not one document signed by the plaintiff and the defendant recording this transaction of money lent and advance. There is not a single document. Your lordship will see the plaint and the petition also, which they filed. So, my lord, both these transactions were done. I'm sorry, my lord, both these arrangements, one which the plaintiff alleges of it being a simple money lent and advance to me, of that there is no documentary evidence, as in the primary agreement is not there. And of the transaction which I say, my lord, is the real transaction, the actual transaction between the parties is also undocumented. And that is why, my lord, all these persons, and here, my lord, I am seeking impleadment of two persons who are associated with the plaintiff.
Okay, if it is there,
yes,
you have to prove your own defense.
No, my lord, here the difficulty is this, my lord. Proof and defense will only be and so far as leading oral evidence is concerned.
No, what you have made out a case in the application, you
Please.
have been made out the said application, the said case in the written statement, and you have to prove by way of evidence.
Yes, my lord. Here, my lord, your lordship.
If suppose
Yes.
this court is allowed this party also,
Yes.
what you will gather?
Now, my lord, if these that is where your lordships are absolutely correct, my lord. Otherwise, the provision for addition of a proper party would never have been there, because once he's impleaded as a defendant, what, my lord, in the lower judiciary is referred to as the pro forma defendant. There's no concept of pro forma defendant, but once he's impleaded as a defendant, then he has to file a written statement. That is where, my lord, that is where there will be a clean breast of the transactions between the parties. Otherwise, the concept.
Okay, written statement.
Yes.
Till now, there is no allegation against these four persons in the plaint.
There is no allegation.
Correct.
Yes, because it doesn't suit the plaintiff.
Doesn't suit the plaint or whatever it may be. And if they have been added as a defendant, and what they will file the written statement, what written statement they will file?
No, my lord. My written
unless and until there is an allegation against.
I follow, my lord. The written statement which they will file, my lord, I will also file my written statement in which I will bring all these allegations. Your lordship's order, if your lordship is with me, your lordship will also record the circumstances in which these people have been added as parties, and they will have proof of my written statement. My lord, they will also have to file a written statement wherein they will either admit or controvert the allegations made. in my
against the written
No,
statement
no.
of the defendant.
No, my lord, they will have knowledge of the case which I am running, my lord, by the written statement. Now, my lord, they may not.
You may take any defense in the written statement, whether
Yes.
this will be effect to the co-defendant.
Yes, now, my lord, there cannot be any claim against on the co-defendant. I cannot have a claim against my co-defendant on the basis of my written statement or any counterclaim. But if the party is added party, now otherwise, my lord, there would be no, if this were to be the argument which the plaintiff will advance, that he can be summoned as witness, then, my lord, there would be no need for having addition of proper party.
No, it is not that. That is depends upon the case to case basis.
Correct, my lord. It has to depend. It can't be that just because I am
It's
making.
not that in one case it is cannot be allowed. It cannot be that
Yes.
the law has to be.
No, my lord. The law has to be case to case on what? On the factual position of each case. Your lordship is. I bow down to your lordship, my lord. Now, your lord, in this case, your lordship will see the factual position, whether to determine the real transaction.
That is the only question.
Yes, whether to determine the real transaction between the plaintiff and this defendant, whether these persons are necessary to be
party.
That is the only. Now, my lord, at this stage, in my respectful submission, my lord, I have to only show your lordship a prima facie case, not a final case for trial. Final case for trial will depend on the evidence which is adduced.
Trial.
But at the prima facie case stage, my lord, I have to satisfy your lordship
They are the necessary part.
that they are that they are parties whose presence would assist the honorable court in determining the real issue between the parties. Now, only for the prima facie satisfaction. Now, my lord, before filing this suit, the plaintiff instituted criminal proceedings against me. It filed a complaint which was taken over by the Criminal Investigation Department of the state of West Bengal. The complaint was identical, that I have borrowed money from the plaintiff, I have not repaid that money, and the plaintiff has thus been cheated. That was the criminal aspect of the matter, cheating. Here is the civil aspect of the matter, recovery of money. But the transaction is the same. Malad, this similar complaint was filed against other companies also, and I'm informed that suits have been filed against other companies who were similarly involved like mine, but I don't know what is the exact nature of that transaction. But such similar suits are pending before this honorable court. Now, when the criminal investigation was filed, then I come to learn of the real transaction which was there.
What has happened to the criminal investigation?
My lord, I have been, that criminal investigation has resulted in a closure, and what's the final report has been filed. The complaint was registered as an FIR, but no charge sheet was filed. Now, the result of the criminal investigation is this. Although, my lord, I don't say that it is binding on your lordship. That I'm not saying. The result of the criminal investigation not binding on the civil court. But the result of the criminal investigation would support the prima facie case, which I'm advancing before your lordship. That being, what was the real nature of the transaction, which I now find out, which I've stated in my subsequent paragraphs, that why this circuitous transaction was done was because, my lord, and I'll show your lordship this FRT report also, was because, my lord, this gentleman, Mr. Pradeep, was also the promoter director of a bank by the name of Lakshmi Vilas Bank. Now, my lord, Lakshmi Vilas Bank was a public listed entity. There are restrictions, my lord, under the under the listing regulations of the stock exchange, as well as the Securities Exchange Board of India, on the acquisition of shares of a listed entity by its promoter. A promoter cannot acquire beyond a certain percentage. Every time the promoter acquires shares, it has to report to the stock exchange. And there is a cap on the promoter's holding. If it wants to exceed that cap, my lord, he has to make an open offer to the public that I want to buy. So, my lord, to avoid all this, and now, my lord, Mr. Pradeep was in negotiations with India Bull Finance for offloading his stake in Lakshmi Vilas Bank at an advanced stage of negotiations. The more the shares of Lakshmi Vilas Bank which he controlled, he could command a higher price from India Bulls. So, to corner the shares of Lakshmi Vilas Bank which were in the market, he entered into an agreement with Sagittarian and Raju Patni that they would buy, and Raju Patni through his various companies, including Sagittarian, would buy shares of Lakshmi Vilas Bank from the market with funds provided by Mr. Pradeep. Mr. Pradeep cannot buy in his own name, so he needs fronts, his benamdars, so to say, who will buy shares from the market on his behalf, on his instruction, with his funds. Now he cannot provide the funds directly. Now to provide the funds to Raju Patni, I was used as a conduit. This was the actual transaction. The actual transaction was not told to me.
How the plaintiff can be tagged over there?
Because the plaintiff was part of this transaction.
Plaintiff, you have taken the amount from the plaintiff.
Correct.
And whatever done in between you, Lakshmi Vilas, KR Pradeep, Sagittarian, and whatever it is.
Yes.
Whether there is an agreement that yes, you will pay the amount, plaintiff will pay the amount to you, and you will assist.
No, Malad, that was the oral agreement between the parties, which was not documented. That is what I told you.
Want to disturb my learned friend. He must be aware that he has also filed tax. He's filed tax on that loan account, saying that it is a loan.
Otherwise, my lord, everything is done to cover up the real transaction. There is an ostensible transaction.
But subject to correction.
My learned senior friend is absolutely correct, my lord. Kindly, just let me rebut. He is absolutely correct that I filed tax. But he has not entered into any loan agreement with me. It is like putting the cart before the horse. First, there has to be a loan agreement. Then the money has to come pursuant to that loan agreement.
Then you will go to the
then I will file tax.
Guidelines of the RBI.
Then, so my lord, here there is no loan agreement. Kindly bear in mind, I have paid tax, that is correct. I have deducted tax at source on interest, but I have not paid him the interest. He doesn't tell your lordship that. I have deducted tax at source on interest to show proper regulatory compliance of a loan transaction. This is evidence which is created to show regulatory compliance, to show that there is a real loan transaction.
That is on merit of the matter.
Correct. So no, my lord, your lordship is seeing the prima facie case where my learned friend wants your lordship to bear in mind that I have paid tax, but I have not paid him interest. I have paid tax, I have not paid him interest, and he has not demanded interest from me also till he comes and files the suit.
No, that's why see, as per the para 10, you are admitted with regard to the amount.
Correct.
Correct.
There is no dispute, but why the amount came and whether I am liable to pay the amount is the only issue in the suit. Now, by this addition of party, I am telling your lordship the prima facie case as to why this amount came. The amount came on the basis of a transaction which was told to me at the time when I entered into the transaction. Subsequently, I come to learn after he files the criminal complaint with the CID that the transaction which was told to me was in fact not the real transaction. The transaction was something more illicit, more nefarious. Now this, my lord, has come to light also from the final report which has been filed by the CID. My lord, kindly come to page
133.
132, please, my lord.
133, come to the 133.
Beg your pardon, my lord?
133.
Yes, 133, my lord. Fine. Your lordship will see at the top of page 133.
Then you come to the main 136, 137 is the brief.
Yes, my lord, 137. This is a final report as civil in nature under section 173 CRPC. And then 136 is the allegations which were made in the complaint which was filed. And here, my lord, there are several companies who are named as having defrauded the plaintiff. I am one of them, my lord, Gyan Traders. There are several other companies. I am told, my lord, that the plaintiff has also filed civil suits against these companies also, which are pending before your lordship. And then your lordship finds at page 137.
Actual facts.
Yes. The loan taken by Pranava City Complex and Pranava Electric Company by giving mortgage to bank at higher rate and strict condition. But on the other hand, loan given to Raju's company without any mortgage or property at lower rate. So they also availed of funds. Now they are giving us loan at a lower rate. Moreover, no conditions are imposed. It is sufficient to prove that Pranava City Complex and Pranava Electric Company has given to Raju Patni for some personal gain. And not, my lord, only money lent in advance, because they can't be doing business at a loss. They are borrowing at a higher rate, giving at a lower rate. Now, Pranava City Complex and Pranava Electric, director is the same, Mr. K. Pradeep. He is also the promoter and MD of Lakshmi Vilas Bank, having head office at Chennai. And he has given the money in different dates, and the money was invested in purchasing shares of Lakshmi Vilas Bank. Your lordship sees that at 137. CA noticed that actually both Pradeep and Raju has conjointly made the business of share purchasing It is the normal practice. It is the fact that though there is no written agreement, but they have done the business conjointly. The nature of the business shows that they have deposited money in the year 2014 and up to 2018, there is no problem in between the two parties. But at the end of 2018, the value of old shares of Lakshmi Vilas Bank has dropped, and then the turmoil came into facts. It is when Lakshmi Vilas Bank share price dropped, the main turmoil has come into picture. Pradeep is also the managing director of Pranava City and Pranava Electronic at the same time, and the loan was given from the said company to Sagittarian in 2014. And later on in the year 2018, when the amount increased, it was divided in 5 companies. So when the amount increased in 2018, it was divided into 5 companies. The money was circulated. The names of these companies are so and so. And later on, money has gone from these said companies to Sagittarian. And lastly, the said money has also been gone to Pranava Electronic Private Limited. So money from these 5 money came to these 5. These 5 routed that money to Sagittarian, and Sagittarian then routed the money to Pranava Electronic. KR Pradeep gave loan to Raju Patni without any agreement. Later on in the year, there must be something wrong. This is the loan agreement. And then balance sheets of the companies are there. Then your lordship kindly comes to the bottom of the page, analysis of shares. Lakshmi Vilas Bank. Raju Patni purchased the shares. Loss occurred. Raju Patni said this. Website shows the share result price. And then they say that this is a proceeding which is civil in nature. In fact, my lord, Lakshmi Vilas Bank was ultimately put under the administration of RBI, and the bank was then transferred to DBS, and the equity shares of Lakshmi Vilas Bank were scrapped.
Yes, that totally closed that.
Yes. So, my lord, this is the prima facie case as far as, my lord, the plaintiff's suit is concerned. As to why your lordship will not. As far as my defense to the plaintiff's suit is concerned, as to what was the real transaction between the parties and not the ostensible transaction which has been made out in the plaint.
Yes.
Now, my lord, in support of this judgment, huh? I had, my lord, on the last occasion, my lord, placed before your lordship 1995 3 SCC 147.
Yes.
3 SCC 147.
Para 7 and 10.
Yes, my lord. Starts on para 6 and then 7 and 10. To bring up, my lord, may I just place 7, my lord, your lordship? Then your lordship has marked the, I don't want to trouble. No, my lord, I don't want. I'm sorry, my lord, I don't want to waste your lordship's time, my lord. Before the vacation, there are a lot of people waiting to have their matters heard. My lord, the second limb of my argument, on the basis of my counterclaim, whether I can be allowed to have a party added, my lord, may I do that on the reopening day, my lord? If Mr. Dutt is not inconvenienced, and your lordship permits me, I have already taken up half an hour. I will confirm. Any date on reopening.
Problem is that only the date and time.
Any date convenient to your lordship.
Sport is too over, but always. That's why I feel very, very embarrassed, my lord.
That is why, my lord, I don't want to trouble your lordship with unnecessary facts, my lord.
Counsel for the respective parties are present. Full stop. Counsel for the petitioner in GA2 of 2022 had argued at length and prayed for some time. Prayer is allowed. Let the matter appear on 20 July at 3 p.m. 20 July 3 p.m.
Deeply obliged.
ये नहीं बोला है तो किसे 6 10 है तो फील नहीं हो पाता. Deeply obliged.
What has happened? 33 over.
That common order in both 55 50s.
55, 56. Yes. It is also dismissed. Manatosh. 18th May it was dismissed. Yes, 184. Yes, dismissed for the not noted. When? 18th May. After 2022. Acha. 22. Then it was 22. May 22. I was there. 1 year. Restore. Where is the restoration now? Then today again nobody's record an order. When it was restored? Huh? Then it is restored. There is no link. Not.
My lord, I am for the plaintiff, my lord. It's an undefinite suit, my lord. My lord, kindly fixes a date for examination chief, my lord.
Undefended suit.
Yes, my lord. I don't have the brief with me, but I am led by Sabyasachi Chaudhary, my lord.
Deed was null and void. By which order is what taken as the undefended?
My lord, that is what I don't have the brief with me, my lord. My lord, I don't have the brief with me, my lord.
As per the prayer made by the counsel for the plaintiff, the case adjourned.
My lord, kindly fixes a date, my lord. For
But when I don't know whether it is undefended, so there is no order at all. Order sheet is there.
no,
Order sheet is there. You are having the order.
no, my lord. I'm not getting the
Then I
brief.
will fix. Otherwise, if no order, how I can pass the
But even the website is not working, my lord. I could have website is not working, ma'am.
our outside? Why? Why could? As per the prayer made by the London Council for the plaintiff, the case adjourned till give the date for witness action. 21st July. 21st July at 2 p.m.
Okay, my lord.
12 noon.
Obliged, my lord. Lordship, for 36, I'm appearing for the defendant. The plaintiff has filed another application. Lordship will kindly come to the prayers of the application once with a very innocuous prayer that they have asked
You
for.
are for the plaintiff.
No, Lordship, I am for the
appearing
defendant.
for the plaintiff.
I'm appearing for the defendant. Lordship had already asked to
I am
close.
filing this application for recalling of the order date in my lord. February 13th, 2023, which is that appearing at page 20, my lord.
Where is the order, application?
Lordship, on the last occasion.
Application, my lord, GS6, my lord.
GS6, Lordship. Lordship, on the last occasion, that is on 13th February, Lordship has passed an order for discovery and inspection of documents and also for suggested issues. As so far as the suit is concerned, Lordship, it had gone into appeal. There was an order, ex parte decree given. The decree was set aside by an appeal court, and then thereafter the suit is already remanded back, Lordship. Now, what they are saying is that it by only arguing the suit, it should be disposed of. How can it be done without adhering to the provisions of the court?
Be recall and suit may fix for argument. Why?
My lord, kindly see, my lord, page 18, my lord. Page 18, my lord.
Of the GA?
Yes, my lord. Yes. My lord, last line, my lord, let the matter appear on 10 January for witness action, my lord. Your lordship has fixed for this matter under witness action, my lord.
Lordship, if I
And
may
my lord-
kindly apprise my lordship in this matter, lordship.
Accordingly, GA was. It is found
Lordship,
from the
there are
record
two
the
orders
plaintiff
which
has
they have
filed
not
a suit
annexed.
against the defendant for his eviction, but there is no counterclaim for any other or any claim on the defendant with regard to the title of the property.
Lordship, there are two orders that has not been annexed.
Yes, 10th January.
My lord, I am led by Mr. Arif Ali. I am led by.
Yes, for 2024. 10 January for witness action. Thereafter, what has happened?
Lordship, thereafter, there is an order passed by my lord on 25th January 2023, which they have not annexed.
Where is that?
Lordship, if Lordship may allow me to hand over.
What has happened on 10th January? Case not
Lordship, on
taken.
10 January, the matter was not taken up. Eventually, the matter came up on 25th January. On 25th January, Lordship, I had apprised it.
Thereafter, the matter was taken on 9th February.
On 9th February, the matter was taken up. Lordship, may I place my case? Lordship, Lordship, the history is important, my lord. This is a suit for recovery of possession.
Correct.
Lordship, after we served the summons on the defendant appeared, filed written statement. Thereafter, they did not take any steps. In those circumstances, the suit was proceeded with ex parte. The suit was decreed, and we got a decree for possession and mean profits.
Correct.
They filed after that, they filed an application for recalling of the decree. Dismissed. They preferred an appeal. In the appeal court says, okay, very well, you put in a sum of rupees 10 lakhs as fixed deposit before the registrar, and the suit shall 9 lakhs, and the suit shall proceed.
Correct.
Once it has come before lordship passed an order saying that 15 December 2022 that the matter shall appear for witness action.
Correct.
My witness action is over.
Correct.
It is for them to bring witness if they do not have any witness.
No. It was the ex parte, then the cross examination is to be done.
Well, that is the cross examination, my lord. We had two witnesses. As on date, my lord, I do not think my second witness is alive.
Whatever it may be, but once the ex parte decree is set aside, then it has come to the de novo. De novo starts from the stage when your argument starts.
Correct.
Correct.
My respectful submission would be
ex parte decree was passed to non-examination of the witness by the cross examination and the witness by the defender. So now they have to get a chance for cross examination of your witness, and if they are entitled to ready to give the witness, then they will give their witness, then the argument in the judgment.
If I may,
but my humble submission would be that the stage at which the suit shall start must be fixed by the appellate court or the court which had recalled the decree.
Correct.
In this case, the appellate court is silent.
Correct.
It has to start, in my respectful submission, has to start from arguments. If not, my lord, their witness action. Lordship, my cross-examination, my examination which is closed, that has not been opened by the appellate court order.
Once the ex parte decree has set aside,
everything.
Lordship.
Once the ex parte decree has set aside, so it is your duty. Either you wanted to adduce any further evidence, you can adduce the further evidence. Otherwise, the defendant will get a chance to cross-examine your witness. You have to produce the witness, and the defendant.
Lordship, it's not about whether I want to. I can produce my witness, my lord. That is not a problem. But once there is no order by the appellate court, by which my examination has been opened. This is my respectful submission. Now, my lord, if lordship feels that I should bring my witness for even that, in that case also this is for witness action. But my lord, my learned friend, in my absence, my lord, it's very unfortunate. In my absence, suppressing the earlier order of 10 December, said that the issues has to be framed, discovery inspection has to are directed to exchange their suggested issues. Lordship, the question, these questions, lordship, does not arise.
Lordship, if I may.
The suit is, lordship, I am put back to 2011.
That's correct. See,
I got a decree in 2012, my lord.
That is correct. If you got the decree, now decree has been set aside. Decree has been set aside. The suit is to be decided on its own fact. Lordship. Then you have to prove your suit. Now they wanted to contest the suit by appearing before the court. Either
They ought to have filed an application, Lordship.
Correct. They have,
But they did nothing.
they did not. Then after the setting aside, how the matter has reached here? Who has mentioned the matter? Once the matter has come to this court, so when the matter first come to this court,
Lordship, it was an application made by the defendant for addition of party. That is how it has come. And more so, Lordship,
that
kindly come
a
to the
misconceived
15
application was filed.
15 December 2022, counsel for the plaintiff and the defendant are present. Defendants filed the instant application. As defendant number 2 in the instant case, no ground came to know that the plaintiff has mortgaged the suit property in adjust. The found the record, the plaintiff has filed the suit against the defendant for eviction, but there is
Lordship,
no counter claim or any claim alleged by the defendant with regard to the title of the property. Yes, that was dismissed.
Lordship, after this order, there has been another order by my lord on 25th of January 2023, and thereafter on 3rd February. Lordship, I'll just hand over. Lordship, by these orders, when I don't have an extra copy. As when on this date, Lordship, when the matter had come, I had specifically informed my lord, apprised my lord, that the matter should not come under witness action. And the suit, the papers, documents lying with the court were not to be traced anywhere. And thereafter, only after checking with the status of the suit, Lordship had directed for issues and to be framed and for witness
At that point of time, my lord,
because at the time when the suit was decreed ex parte, there was nothing taken place, no issues framed, and no documents of inspection or discovery done. Although even after my lordship's order, we have already sent a letter to the advocate on record for discovery inspection. Till date, there is no reply to the letter.
They are exhibited. What are they saying?
No. See,
they discovered documents. Where do I get those documents? They're exhibited before lordships.
These two orders
They
are
do not know basic.
placed in their application. It is an order of the court where the documents were not being traced.
Have you deposited 9,25,000?
Yes, Lordship, it has, and they have even they were already enjoying the interest out of that money.
Rightfully so.
Let
As
that
per
court decide that.
order of the appellate court,
Lordship,
two
because
orders.
they have suppressed material facts on record. The agreement that they had entered into is also malicious with a malicious intent that they had done.
An agreement with a malicious intent. So they do not want to.
Till
Very well. Very well.
Agreement states.
So if they do not, they are saying that the agreement is malicious, they should immediately vacate.
Let the court go.
They are in the property on the basis of the agreement.
After the division bench order, then 15 December, your application was dismissed. GA was dismissed.
Lordship. And the suit was fixed for witness action.
Witness action on 10th January. 10th January, matter was not taken up, and 25th of January, the matter was taken up.
Yes, on that
25th January, the record has not come. Record was not.
Record was not there.
Then thereafter, the
9th
February. 3rd
February.
February. Lordship.
There are 3rd February. Just now the court has received the information, the court has received, and then 8th February.
On those two dates also.
Just a minute. Then 8th February, not then 9th
Then
February.
9th February, Lordship.
As per the counsel defendant, appear on 13th February. 13th February, yes.
What are they saying?
Yes. What has happened? After your order, they have neither you nor they came before this honorable court for put up the matter to bringing the order.
The case records were not available.
That's why one application was filed by the defendant by impleading the HDFC as a party to the suit. That was dismissed.
Lordship.
In December. But that was in J application. Correct.
Lordship.
J application was dismissed. Then the suit was fixed. The suit record was not available. So, but the record was not available. Unfortunately, this court has passed an order for witness action on 10th January.
Lordship.
Correct. 10th January, 15th December, when the GA was dismissed, then on that day, 10th January, this court, because there was no original record, was not available.
Lordship.
This court has picked
Lordship.
the case
It was
as
not there.
witness action. Then the original record.
8th February, it was traced out. 9th February,
13th
Lordship.
On 13th February, the record was before this court.
Absolutely.
And when
13th February, Lordship, we were not present.
You are not present, but after going to the record, after going to the
my learned
record,
friend ought to have
that's why
placed the earlier orders.
no. After going through the record, not by the submission. Kindly see, after going through the record, this court find that it was the ex parte. So there was no discovery and inspection, there was no issues. Once the matter has been set aside.
There is the question of discovery inspection because the originals are exhibited. Lordship, that is why saying, Lordship, in view of the submission made by the counsel for the defendant, let discovery inspection. Lordship, the submission was made completely either misconceived or.
Okay, this court will go by your submission. So what you have submitted your document was exhibited. Tomorrow they will get an opportunity. How they will exhibit the document unless and until they will not disclose the document? And
For their documents.
Whatever it may
For
be.
their documents.
Whatever if you say you say you have disclosed all the original documents.
Lordship, there is also an order. There is also an order. Lordship, we have to in the original side, Lordship, we take out an affidavit, our master summons, directing the defendant to discover their documents. Lordship, that order is also there by the master. The period had
that is
that
earlier.
period earlier, my lord.
That
They
is
missed
earlier.
their chance to discover documents.
That earlier, that's why they have not come forward ex parte.
Lordship.
Ex parte was going
Lordship.
on. Now ex parte was set aside. Ex parte was set aside. Now it has
Now, my lord, the only question is at which stage it should start from.
It has to be staged from the inspection, discovery and inspection, because now they have to give an
Lordship, in that case, my lord, let them inspect those documents from the lordship's records.
That's why now
Lordship, if they want to discover documents, let them do that.
I will correct the record in your application itself. You didn't want to include any further documents.
No, my lord.
Correct.
No, my
So
lord.
I will record that the as per the submission, plaintiff has already disclosed the document which was exhibited during the ex parte evidence, and you are not intended to exhibit any, produce any further.
I believe they have also inspected those documents.
You are not interested to further
No.
disclose any
No,
further
no.
document. So she will be given 1 week time to disclose her document to you for inspection, and you complete the inspection within a week after vacation. And in the meantime, suggested issues may be completed, come a framing of issues, and evidence will be.
Lordship, in the meanwhile, Lordship, there's only one direction that I'm seeking from my Lord. That is, let them disclose only one single document, that is the deed of mortgage of the flat in the property in concern, concerning the suit.
Madam?
Because, Lordship, there is...
Madam, once they are telling that they will not disclose any further document which has already they have disclosed. So why the court will ask them to produce some document?
Lordship, that is a very...
Let you come with the evidence. We'll see to that.
Lordship.
Court cannot ask the evidence from the plaintiff or from the
Lordship,
defendant.
Lordship would appreciate the submission. She is in possession on the basis of an agreement.
I appreciated her evidence from the application when they are filed bringing the
Lordship.
as a plaintiff as the
On
defendant.
that basis, Lordship, she's now challenging my title.
That's why that has been recorded.
It is an
That's why
absurd.
that was recorded in the application which I have dismissed.
Lordship. That is why it has been dismissed.
Counsel for the respective parties are present. Full stop. The plaintiff has filed an application being GS6 of 2023, praying for recalling of the order dated 13 February 2023 and fixing the matter for argument. Full stop. Counsel for the defendant raised objection and submits that initially the suit being CS number 283 of 2011 proceeded ex parte, and this court has passed ex parte decree. Subsequently, the defendants have filed an application before this court for recalling for setting aside the ex parte decree, but the defendant fails. Subsequently, they preferred an appeal before the appellate court. The appellate court being the appellate court in APOT number 340 of 2013, dated 13th August 2013, set aside this ex parte decree with the condition that the defendant shall deposit an amount of rupees 9,25,000 within 3 months. Counsel for the defendant submits that in compliance of the order of the appellate court, the defendant has deposited the said amount. Subsequent to the order passed by the appellate court, the defendant has filed an application being GA. What application? In GA5 of 2021, praying for addition of HDFC Bank as party defendant, but by an order dated 15 December 2022, this court has dismissed the said application and fixed the matter for witness action. Full stop. This court finds that by an order dated 15 December 2022, this court has fixed the case for witness action, but when the record of CS 283 of 2011 was brought before this court, was produced before this court finds that the discovery and inspection of the document were not completed and issues were not framed. Accordingly, by an order dated 13 February 2023, this court directed the parties to complete the discovery and inspection of the documents within 4 weeks and to complete the suggested issues and to exchange the suggested issues and fix the matter on 21st March 2023 for framing of issues. Full stop. Now the counsel for the plaintiff submit that they have already disclosed the document which were exhibited during the evidence of the plaintiff witness at the time of ex parte evidence, and they are not inclined to adduce any further evidence in view of the further document. In view of the submission made by the counsel for the plaintiff, the defendants are directed to disclose their documents within a week and disclose the document within a week for inspection within a week after the after opening of the court of summer vacation to the plaintiff for inspection. Full stop. The plaintiff is at liberty to inspect the document disclosed by the defendant within a week thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues.
Lordship, in that case, the exhibits that they have already, it's already submitted before the court, let them provide us a copy with those exhibits at least.
Full stop.
We shall do that.
Last minute. No, prior to that document, no? Thereafter, full stop. As the document which the plaintiff is relied upon, at that point of time, the defendant had not appeared, and accordingly, the plaintiff is directed to disclose the said document to the defendant within a week after a reopening of the court after summer vacation. 1 week after the reopening of court after summer vacation.
Lordship, for cross-examination also.
Full stop. In the meantime, the parties are also directed to complete the suggested issues, exchange the suggested issues. Full stop. In view of the above, GA number 6 of 2023 disposed of. Full stop. Let the matter appear on.
Lordship, will fix a date, madam.
Let the matter appear.
I'm certain.
Are you fixing a date for framing of issues?
Lordship.
Let the matter appear on 20th June 2023 under the heading framing of issues. Complete this, madam.
Lordship.
No further chance will be given.
Lordship.
20 June. 20 June for framing of issues. When the issues will be framed, then the evidence. You see, whether all the witnesses are there, then you produce and they will cross-examine.
My second witness, I think he has passed away. I shall try to find out.
Next.
Good.
हाँ था सब फाइल इतना दिन कहाँ था None appears on behalf of either of the parties. For the interest of justice, the case is adjourned for 2 weeks. Let the matter appear on 8th June.
In item number 39, your lordship, I am for the defendant number 3. There are 2 pending applications in that suit.
That's a J4 and J5.
Yes, your lordship.
Already
J5 and J6, your lordship.
4 and 5.
4
and 5.
4 is not ours, your lordship. The one of
Intervening
the
application.
yes, one application is for substitution of for one of the plaintiffs, your lordship. The applicant is claiming to be the widow of such plaintiff, which we are challenging, your lordship. And your lordship, the subsequent application is by us under section 348 with 195 of CRPC, challenging the only document brought forward by the applicant in the application for substitution is a marriage certificate, your lordship, which we are saying is a forged document, because your lordship upon perusal will find that such the marriage registrar who has solemnized the marriage, your lordship, did not have the jurisdiction.
What is the suit for?
The suit is for delivery of and cancellation of certain deeds of conveyance, your lordship.
So nobody is there.
Your lordship kindly keeps it peremptory against the applicant.
Counsel for the defendant number 3 is present. None appears on behalf of the plaintiff and the other defendants. For the interest of justice, the case is adjourned for 2 weeks. Let the matter appear on 7th June 2023. In case none appears on behalf of the plaintiff.
Your lordship, applicant.
Plaintiff. Because for the plaintiff.
No, your lordship.
None appear, in case none appears on behalf of the plaintiff, appropriate order will be passed.
Very well.
Next.
My lord, I am for the plaintiff. My lord, I pray for a short passover. My senior
Lordship.
is appearing in court number 16.
Lordship, on principle, I never object a passover or an adjournment, but this is possibly the 5th occasion. Twice the matter was specially fixed. Twice the matter was
Witness is
for
present.
4 witnesses. I don't know, my lord, whether the witness is present or not.
My
A song is.
senior is appearing in court number 16.
I am closing it. Lordship, this is the 4th time the same.
Yes.
While senior is up,
But kindly,
start before a different court.
my lord, kindly.
Lordship, on a perusal of the records, my lord will see the matter was fixed twice under the heading specially fixed. Thereafter, my lord had given them a last opportunity. Pursuant to that, the matter was removed from my lord's list. Then again, it was mentioned, brought back. Not here again, my lord. My lord, the suit is for alleged malicious prosecution. If submissions of this kind are made every time.
I am closing this, then I am fixing the DW.
Kindly.
My lord, kindly do not.
And
my lord,
What can be done, madam? Order speaks so.
My lord, he will come. My lord, kindly.
When
give
he
a
will
short-
come?
Within
When the matter is fixed and he has not come, and the order sheet speaks that every day you are taking time.
My lord, kindly give 20 minutes. He will come.
20 minutes, the court time will be over.
I'm trying to reach my lord. Kindly give us a short passover.
Short passover. Let us see.
Grateful.
41. Yes, who is there? None appears on behalf of the plaintiff. None appears on behalf of either of the parties. The matter was fixed on 17 February 2023. And the counsel for the plaintiff submits that he has gotten information that the sole defendant had passed away and prays for time for taking steps. Till date, no steps has been taken and the matter is called. No adjournment, no accommodation is sought for. For the interest of justice, the case is adjourned for 2 weeks. Let the matter appear on 9th June 2023. In case on the date fixed, none appears on behalf of the plaintiff and no steps has been taken, appropriate order will be passed. Next.
Lordship, item number 42, I am for the plaintiff. I am being led by Mr. Shomaba Ghosh. On the last occasion, my lord had directed to file affidavits in their application, which is
My
DAC.
affidavit is ready, my lord. I beg to
So
file
is
my
mine,
affidavit in
Lordship.
reply, my lord.
Opposition and reply both ready?
Both are ready, my lord.
And I will pray before your lordship, my lord, that your lordship may kindly fix up a date for the
Lordship
hearing.
kindly fixes a date for arguing the present
What is the
application.
application?
There are two suits, my lord.
What is the application?
This application is for our application for leave to file the written statement.
Lordship, suit of 2014.
There are several reasons why
My senior will indicate to your lordship.
Counsel for the respective parties are present and file the affidavit in opposition and reply thereto. Let the same be cut with the record.
Served upon them, my lord.
The counsel
Lordship, even the opposition is served upon.
Counsel for the respect served.
Yes,
Yes, my lord.
Counsel for the respective parties have exchanged their affidavits. Let the matter appear on 12th June for hearing.
12 June. Much obliged.
Grateful, Lordship.
Next. Next.
My lord, I am appearing for the plaintiff in this matter. My lord, it's a changed brief. It's a matter of 2010. It's not been possible to retrieve the records of the case. I don't have a copy of the plaint, my lord.
Item number? (2014) suit filed.
My lord, it's a changed brief.
Yes.
It has not been possible to retrieve the records of the case, my lord. I will make an appropriate application before this court to retrieve the records because I have not been able to obtain even a copy of
But
the
as per
plaint.
the report, madam, there are 4 defects since 2014.
Possibly, my lord may grant me the opportunity to inspect the records and take out a certified copy of the same because I do not have a copy of the entire brief, my lord. It's a changed brief. We will be taking over the matter afresh. No, my lord.
How the certified copy?
My lord, I will take necessary steps.
Who you are appearing for?
I am appearing for the plaintiff in this matter, my lord.
Plaintiff.
Yes, my lord.
Defamation suit. It is a defamation suit.
My lord, I will file my wakalatnama, come on record, obtain certified copy of the entire records, and my lord kindly grants me some time for the same.
What's the good name, madam?
Miss Utsha Dasgupta.
Had appeared and submitted it. It is a change brief, and she may be allowed time to file wakalatnama. Leave is granted. Full stop. It is fine from the record. The suit is filed in the year 2014, and there is a report that there are altogether 14 defects which has not been rectified by the plaintiff till date. Full stop. Counsel for the plaintiff submit that. Now counsel for the plaintiff, so and so, Mr. Smith, so and so submit that. She may be given leave to inspect the case record so as to enable the plaintiff to take appropriate steps. In view of the above, leave is granted to so and so to inspect the case record of so and so and to take appropriate steps for rectify the defects as pointed out by the department. Let the same may be rectified within 6 weeks from date. Let the suit be appear along with the report of the department on 28th June 2023.
Grateful, my lord.
Next.
My lord, I'm from the plaintiff. I'm
Yes.
paying for not today.
Not today. I am dismissing it. 2015, you are not taking steps. When the matter is listed, not today. What
advocate
purpose it
record
is? If the plaintiff is not ready to proceed with the matter, why the court will take burden of that?
My lord, the
Have you gone
advocate
to the
record.
court? Since 2015, the matter is pending.
My lord, kindly.
Who is for the defendant?
Defendant. Defendant.
You are appearing for the defendant. Then have you filed the written statement? Nothing. Writ of summon is on record. As per the prayer made by the counsel for the plaintiff, the case adjourned for 2 weeks. Let the matter appear on 7th June. Next. None appears on behalf of the '15 is dismissed for default. Interim order, if any, shall stand vacated. Next. Not today.
48.
My lord, I am appearing for the plaintiff in this matter. My lord, the defendant has
Settled.
filed his written statement in the matter.
You are interested to proceed with the matter?
Yes, my lord. My lord, directions may be passed for inspection discovery.
Counsel for the plaintiff is present. None appears on behalf of the defendant. Full stop. It is fine from the record. Defendant has filed written statement. Full. Counsel for the plaintiff submits that a direction can be given for discovery and inspection of the document. Full stop. In view of the submission made by the counsel for the plaintiff, discovery and inspection may be completed within 4 weeks from date. Full stop. In the meantime, the parties are also directed to exchange the suggested issues. Full stop. Let the matter appear on 27 June 2023 for framing of issues.
Grateful, my lord.
Your Lordship, I am for the plaintiff. This is my suit, Your Lordship. Money claim on account of goods sold and delivered, my lord. Now, what had happened, Your Lordship, the defendant has not been appearing throughout, only after filing of written statement. Your Lordship had thereafter directed to file the judge's brief of documents and proceed ex parte. Then, Your Lordship, I had sought leave to file supplementary judge's brief of documents. Only difficulty is my advocate on record, Mr. Burlia. He is not well, so he had left court for some personal difficulty, my lord. So the original is not with me. I am the counsel in the matter, Your Lordship. If Your Lordship kindly keeps it after vacation on the opening day, we shall file it. And also, Your Lordship, there is another leave that perhaps is required to be sought. Since they had filed written statement, they were there till then. Your Lordship, maybe issues should be framed. If Your Lordship so pleases, we could also bring suggested issues on that day. Is Your Lordship, in case issues not framed, Your Lordship.
Framed, madam. 25th November.
I apologize, Your Lordship.
Five
I
issues are
apologize.
there.
Yes, Your Lordship. I apologize.
Because unless and until issues are not there, then
Yes. Only they have filed written statement. Thereafter, Your Lordship directed.
you are for the plaintiff.
I'm for the plaintiff, my lord.
Counsel for the plaintiff is present. None appears on behalf of the defendant. Full stop. Counsel for the plaintiff prays for extension of time to file the additional judge's brief of document. Let the same be filed within a week after reopening of the court.
Grateful.
Let the matter appear on 13th June.
Grateful, Your Lordship.
The matter was listed on 17 February 2023, but none appears on behalf of the plaintiff. But for the interest of justice, the case is adjourned for 2 weeks. When the matter is listed today, none appears on behalf of the plaintiff. No accommodation is sought for. It is fine from the record, the plaintiff is not interested to proceed with the matter. Accordingly, CS number 15 of 2016 is dismissed for default. Interim order, if any, stand vacated.
My lord, item number 53, my lord. I appear on behalf of the defendant numbers 2 to 4. I appear for the plaintiff, my lord.
Lordship, I appear for defendant number 1.
Lordship, this is that matter, my lord. Contested probate proceedings. My lord had appointed retired Justice Alok Chakraborty as the special referee to adjudicate upon the family disputes, my lord. My learned friend who's appearing for the defendant number 1 had sought for a time to seek instructions whether they want to withdraw their application or not.
For instructions, Your Lordship. Your Lordship, pass over, Your Lordship. Mr. Karmakar is on his legs. He'll be there any moment.
The last matter.
Yes, Your Lordship. Your Lordship. Your Lordship, he's on his legs, Your Lordship.
Have you taken instruction? What is you will proceed with this application?
Yes, Your Lordship.
Okay. Okay, just pass it to her. Call the passover matter. Item number 40.
May it please Your Lordship, I am led by Mr. Das.
Who is for the plaintiff?
My lord, I am for the plaintiff.
Yes, where is your senior?
My senior could not come till may I start?
Yes. Witness is present?
Yes.
Yes.
First time. First.
যেটা বলছি সেটা রিপিট করবেন জোরে জোরে। এই মামলায় সাক্ষ্য দিতে এসে
এই মামলায় সাক্ষ্য দিতে এসে
আমি যা বলবো সত্য বলবো,
যা বলবো সত্য বলবো,
সত্য বই মিথ্যা বলবো না,
সত্য ওই মিথ্যা বলবো না,
কোনো কিছু গোপন করবো না।
কোনো কিছু গোপন করবো না।
আপনার নাম?
সমীর ভট্টাচার্য। সমীর ভট্টাচার্য।
আপনার নাম?
প্রয়াত মানে লেট গোপালচন্দ্র ভট্টাচার্য।
আপনার বয়স?
টিপু এসে মাইয়ার।
আপনি আপনি কি করেন?
বিজনেস করি।
আপনার অ্যাড্রেস বলুন।
177D বিবেকানন্দ রোড, কলকাতা 6।
Mr. Bhattacharya, kindly tell my lord, how are you with this matter?
এই মামলার সাথে কিভাবে যুক্ত?
মাই লর্ড, আমি দিল্লিতে বর্তমান যে প্রেজেন্ট ডিফেন্ডেন্ট এসসি সাইগল, উনি আমার বিরুদ্ধে দিল্লির ডিস্ট্রিক্ট কোর্টে একটি 138 এনআই অ্যাক্টে আন্ডার সেকশন 138 এর একটা মামলা ফাইল করেছিলেন।
The defendant of this case filed a case. No, defendant SC Saigal. There are two defendants. SC Saigal filed a case against me at Delhi
District Court.
Delhi District Court under NI Act 138 NI Act. Under section 138 of the NI Act.
কেসটা পুরোপুরি ফলস কেস করেছিলেন এবং হ্যারাসমেন্ট করার জন্য।
This case was lodged falsely and harassed me. No, no. He has filed this said case against me. He has filed this said case against me. He has filed this said false case against me only to harass me. Yes.
এই কেসটি ম্যালিসিয়াসলি 7 বছর ধরে উনি আমার বিরুদ্ধে চালিয়েছিলেন দিল্লিতে, এবং কলকাতা থেকে আমার দিল্লিতে নিয়ে যেতেন। এবং ওই হ্যাঁ না, একটা ব্রিদিং প্রবলেম আছে আমার। ঠিক আছে।
Because of this case, I had to proceed to Delhi on several occasions for 7 years from Kolkata to Delhi to attend the said case. Ito.
এই কেসটার জন্য আমার প্রচুর ক্ষতি হয়, প্রথম কথা বিজনেসের এবং আর্থিক।
I have made a loss. I had suffered a loss in my business and personally
ফাইন্যান্সিয়াল
and in my I have suffered financially and business loss.
হ্যাঁ
বলুন।
2003 এই সময় এই এসসি সাইগল আমার কলকাতা পিয়ারলেস ইন হোটেলে একটি মিটিং ডাকেন।
Mr. S. Saigal called me in a meeting.
এসসি সাইগল
Called me in a meeting in the year 2003. In a meeting in the year 2003. কোন হোটেলে বললেন?
পিয়ারলেস ইন হোটেল কলকাতা।
Fearless in Hotel, Calcutta. Calcutta.
সেটেলমেন্টের জন্য আমাদের ডিউস যা আছে ওনার বা আমার।
For a settlement, whatever due between us.
এটা অনেকটা বলার আছে।
বলুন বলুন।
স্যার, এই সেটেলমেন্টের জন্য উনি যখন ডাকলেন, উনি আমার সঙ্গে যে মিটিং করলেন, তাতে ওনার সঙ্গে যে সেটেলমেন্ট যখন হলো, দেখা গেল ডিউস আমার কিছু নেই ওনার কাছে, আমি ওনার কাছ থেকে পাবো।
At the time of discussion, it was found that there is no dues against me, but the amount is to be recovered from him by me. Dues are to be recovered from him by me.
উনি যখন সেটেলমেন্টের যখন আমাদের হিসেবটা হলো, হ্যাঁ, তখন উনি যেটা বললেন যে আপনার কি ডিউজ আছে আমি দেখিয়ে দিলাম, ওনার সমস্ত হিসেবের পর দেখা গেল উনি 277 এর জন্য আমাকে এই ফলস কেসটা করেছেন, মানে আমার ডিউজটা রয়েছে 277, আমি ওর কাছ থেকে পাবো। আর আমার কাছে মাই লর্ড যে ড্যামেজ মাল ওনার কোম্পানির ছিল বা আনসোল্ড গুডস যেগুলো ছিল সেগুলো সমস্ত পড়ে রইলো, আমি বললাম ওগুলো রিটার্ন করার জন্য, কিন্তু উনি ওগুলো বললেন ঠিক আছে আমি সেটেলমেন্ট করে আপনাকে টাকা রিটার্ন করে দেবো, করে উনি দিল্লিতে চলে গেলেন।
ছোট ছোট বলুন।
আচ্ছা,
ছোট করে বলতে হবে আপনাকে।
Usually when I spoke for settlement, it was found out, transpired that the defendant transpired that the defendant was is not entitled to any amount, and that whereas I was entitled to 277 and I was entitled to
877.
8 rupees 277 from the defendant.
The defendant filed his case against me, defendant went back to Delhi and filed his case against me. Defendant went back to Delhi. He filed his case against me for the recovery of the
No, উনি অন্য কেস করেছেন।
file a case against
হুম।
File a case against me. আস্তে আস্তে করে বলুন, ছোট ছোট করে বলুন,
আচ্ছা,
তাহলে শুনতে যাবেন।
একটা করে সেন্টেন্স করে পড়ুন।
ছোট ছোট করে বলুন।
আমার যে ড্যামেজ গুডস গুলো ওনার কোম্পানির পড়েছিল সেগুলো উনি রিটার্ন দিলেন না।
The damaged goods which were in my godown, they have not taken this. Which was lying in my godown, they have not taken. They have not taken. Not taken back.
টেকেন ব্যাক।
তারপর
এই অ্যামাউন্ট হচ্ছে 8 থেকে 9 লাখ টাকার মতো ছিল তখন দ্যাট পিরিয়ড।
it was approximately 8 to
9 lakhs। এরপর উনি দিল্লিতে চলে গেলেন।
After that he returned to the Delhi. তারপর
উনি আমার এই ব্যাপারে কোনো কিছু যোগাযোগ না করার জন্য আমি ওনাকে চিঠি দিই অনেকগুলো।
I have written several letters to him due to he not made any conversation, due to not made any conversation with me. তারপর বলুন।
উনি আমাকে অনেকগুলো চিঠি দিয়েছিলেন কিন্তু চিঠিগুলো কোনোটাই আমার চিঠির উত্তর নয়।
He had written several letters to me, but the letter was not in
কানেকশন উইথ দিস।
connection with the letter which was not in connection with the letter which I was sent to him. I was sent to him.
উনি আমায় যে চিঠিগুলো দিয়েছেন সেগুলো একটু মেনশন করে দিচ্ছি। সেই চিঠিটা হচ্ছে যে জিনিসের আমি বিজনেস করতাম সেই জিনিসের কোনো উনি আমাকে মাই লর্ড কোনো উত্তর দেননি, দিয়েছিলেন অন্য গুডসের যে মালটা আমি কোনোদিন সেলই করিনি। এটা দেখুন।
He is replying in his letter regarding the goods which I used to.
He has not replied to the letters issued by me. The replies were made only in respect. And he has replied to the letters. He has not replied to the letters
issued by me.
He has not replied to the letters issued by me, but he has replied to letters in respect of other goods.
এবার হচ্ছে উনি ওই চিঠিগুলো দিয়েছিলেন, উনি কি কি চিঠি দিয়েছিলেন তো বলছি, তার মধ্যে একটা দিলেন আমার চিঠির উত্তরে একটা দিওয়ালি গ্রিটিংস কার্ড উনি আমায় পাঠিয়ে দিয়েছিলেন চিঠির উত্তর হিসেবে।
In reply to my letter, he has sent a Diwali greeting to me.
এরপর যখন কোম্পানির লোক আমার কাছে আসতো ওনার অফিসিয়ালরা রিপ্রেজেন্টেটিভ,
After that, when his representative came to my office,
Company's representative, when his company representative come to my office,
তাদের আমি যখন বলতাম যে আমার সেটেলমেন্টের ব্যাপারটা কি হলো, টাকার কি হলো,
When I asked them to what happened about my settlement and about my money, what has happened about my settlement and about my money, then
ওরা বলতেন যে সেটেলমেন্ট করে টাকা আপনাকে ফেরত পাঠিয়ে দেবো।
they have said that we will refer. They have said that they will return back my money.
তারা হচ্ছে নাম মিস্টার এমআর নন্দী।
They are Mr. M.R. Nandi.
নন্দী ZBM ছিলেন উনি।
He was ZBM. আচ্ছা।
জোনাল বিজনেস ম্যানেজার। তারপর পলাশ ভৌমিক সেলস ম্যানেজার।
সেলস ম্যানেজার।
দিল্লি থেকে এসেছিলেন মিস্টার এনকে যোশী।
Mr. N.K. Joshi, who came from Delhi.
আরো ছিলেন অনেকে।
And many other people came there. And there are many other people.
এই সময়টার মধ্যে ওনারা আমার ক্যাশে মাল দিতেন এবং ক্যাশ টাকা নিয়ে চলে যেতেন, পুরোনো কোনো ডিউস সেটেলমেন্ট করতেন না।
Within this time, they used to give the goods in
cash purchase
by cash and they used to give me goods by cash. In this time, they used to give the goods on payment, but they have not taken any decision with regard to my dues amount.
ওনারা বলতেন যে আমাদের প্রোপাইটার যা করবেন তার। মিস্টার এস.সি. সাইগাল ওজন আয়ুর্বেদিক্স এর প্রোপাইটার ছিলেন এবং ওজন ফার্মাসিউটিক্যালস এর উনি একজন ডাইরেক্টর।
Mr. S. Saigal was S.C. Saigal. S.C. Saigal was a director of
proprietor of Ozone Ayurvedics. Ozone Ayurvedics.
Ozone Ayurvedic.
And one of the director of Ozone Pharmaceuticals.
One of the director of Ozone Pharmaceuticals.
ওনার কথার উপর ভিত্তি করে কিন্তু আমি সেটেলমেন্ট বসেছিলাম যে আমাকে টাকাটা রিটার্ন করবে।
I was set for settlement as per his. I was waiting for the settlement.
Return the money.
Waiting for the settlement so that I can get the amount.
এই দিল্লিতে কেসটা চলাকালীন আমার যে বিজনেসটা চলতো সেটা আমার পুরোপুরি ফাইন্যান্সের উপর চলতো, ব্যাংক ফাইন্যান্স। আমি ক্রেডিট লোনের উপর বিজনেসটা চালাতাম।
I used to run my business on cash credit
loan.
Cash credit loan
from SBI.
From SBI. During the pendency of the case. In Delhi.
মাইলর্ড, এই দিল্লিতে কেস করার জন্য আমার টাকার তো প্রথম প্রবলেম তো অ্যারাইজ করলোই। সেকেন্ড হচ্ছে আমি কোম্পানির ওই কেস করার জন্য অন্য যে কোম্পানিগুলো ডিস্ট্রিবিউটরশিপ ছিল সেগুলো কিন্তু আমি চালাতে পারছিলাম না, যেহেতু আমার ফাইন্যান্সিয়াল ক্রাইসিস তৈরি হয়েছিল।
To run this business, I have suffered financial crisis due to non-payment of the amount by the defendant.
Other company
Amount
to other companies. এই ক্যাশ ক্রেডিট লোনটা আমার শেষ পর্যন্ত ইনক্লুড হয়ে যায়।
The cash credit loan was become included.
হয়ে যায় এবং উনি ডিআরটি তে আমার অলরেডি একটা কেস ফাইল করেছে দিল্লি কলকাতা।
And he has filed a case at
SBI ফাইল করে।
And SBI filed a case against me. SBI has filed a case against me. কোথায় বলুন?
কলকাতা ডিআরটি তে।
কলকাতা ডিআরটি।
Debt recovery tribunal.
Debt recovery tribunal.
এইটাই তো কোশ্চেন অনেকটা। এরপর যখন আমি ওনাদের আরেকবার চিঠি দিলাম, তার উত্তরে উনি আমায় পাঠালেন ফার্মাসিউটিক্যালস এর একটি প্রাইস লিস্ট।
After that, when I have written a letter to him, they have replied that keep reply ছিল
মেডিসিনের প্রাইস লিস্ট পাঠিয়ে দিলেন আমার চিঠির উত্তর হিসেবে।
send me the list of price list of the medicine.
এই কেসটা করার জন্য আমার রেপুটেশন খুব নষ্ট হয়ে যায় চারিদিকে, কারণ আমার একটা গুডউইল ছিল সেটা নষ্ট হয়।
My reputation was spoiled because of this case.
কলকাতা থেকে আমার দিল্লিতে অ্যাডভোকেট নিয়ে যাওয়ার জন্য আমার প্রচুর খরচ হয়েছে এবং ওখানে ফুড এন্ড লজিং এর জন্য খরচ হয়।
I spent a lot for the I spent a lot for this case.
No, I had spent for my lawyer, for traveling from Calcutta to Delhi, fooding and lodging at Delhi.
এবং এই যে ট্রাভেলিং অ্যালাউন্স যেটা খরচ হয় সেটাও আমার ট্রাভেলিংসটাও খরচ হয়, এক্সপেন্স। অ্যাডভোকেট ফিস খরচ হয় এর জন্য।
I had also to spend the advocate fee for the said case.
এই জন্যই আমি ড্যামেজ স্যুট ফাইল করি ওনার বিরুদ্ধে যে আমার টাকাটা তুমি দাও, এত টাকা তুমি খরচ করিয়েছো।
For that, I have filed a damage suit to recover the money
Which have sustained the damage. I sustained the damage.
May I proceed? Sorry, I was starting.
No, your witness is
Giving good answers. I am not required.
even your junior was not required.
Competent witness.
ব্রিদিং প্রবলেম হচ্ছে। হ্যাঁ, উনি তো প্রশ্ন করবেন।
Mr. Bhattacharya, since when you are doing business with the defendant?
কখন থেকে ওই ডিপেন্ডেন্ট
2001
since 2001.
Kindly tell this court what was the nature of business that you were doing with the defendant.
আপনি কি ধরনের ব্যবসা
You are doing with the defendant.
Key nature of business.
আমি কনজিউমার গুডস এর ব্যবসা করতাম, ডিস্ট্রিবিউটারশিপ।
I used to do consumer good business. I used to do consumer good business
অ্যাজ ডিস্ট্রিবিউটার।
as distributor.
Mr. Bhattacharya, you just now referred to a check-bound case being filed in Delhi. Full stop. Kindly tell this court what happened to that check-bound case in Delhi.
কি হয়েছিল চেক বাউন্ড?
যে কেসটি ফাইল করেছিল আমি প্রথমেই বলেছি ওটা ফলস কেস ছিল পুরো।
As I have earlier said, the case which was filed against me in Delhi, it was false. Against me in Delhi, it was totally false. বলবেন?
লিখছেন তো। হ্যাঁ, এবং এই কেসটা 7 বছর ধরে উনি চালিয়েছিলেন ম্যালিসিয়াসলি।
And the case was pending since
7 years.
disposed of. এখন তো ডিসপোজ হয়ে গেছে কেসটা। The case was disposed after 7 years of
The case was pending for about 7 years. The case was pending for about 7 years.
এখন ডিসপোজ হয়ে গেছে।
Was pending. Now it was disposed of. Now it is
case
disposed of.
was pending for the last 7 years. Now it is disposed of.
এই কেসটা হয়ে যাওয়ার পর উনি কিন্তু কেসটির রায় মেনে নেন এবং উনি কোনো উচ্চ আদালতে আর এর বিরুদ্ধে আপিল করেননি।
After the disposing of the case,
He has not preferred any appeal against the said order. He has not preferred any appeal against the said order.
এরপরেও আমার সঙ্গে ওনার কথা হয়েছিল, আমি বলেছিলাম আমার টাকাটা রিটার্ন করে দিন, উনি বলেছিলেন দেবো।
after that, I have made a conversation with him, but I have made a conversation and I asked him to get back my money, and he assured me to.
I asked him to return my money.
To return my money. Asked him to return my money, and he said that he will return the money.
He assured me that
Assured.
he will return the money.
Mr. Bhattacharya, do you have any place of residence in Delhi?
মাই লর্ড আমার কোনো রেসিডেন্সিয়াল ওখানে কিছু ছিল না।
No, I have no residential.
Mr. Bhattacharya, do you have any personal transportation arrangement in Delhi?
মাই লর্ড কোনো কেউ ট্রান্সপোর্টেশন নেই।
Do you have any relative in Delhi?
না, কেউ দিল্লিতে কেউ রিলেটিভ নেই।
Who used to look after your case in Delhi?
আমার লার্নিড অ্যাডভোকেটরাই ওটা দেখতেন কেস।
প্রশ্নটা শেষ হোক তারপরে বলুন।
আচ্ছা,
To look after my case.
কি বললেন? How many advocates you had in Delhi in your check bounce case?
অল্টারনেটিভ তিনজন অ্যাডভোকেট যেতেন আমার সঙ্গে।
Alternatively, advocate.
The advocates who used to represent your case in Delhi, are they practicing in Delhi or Calcutta?
না, কলকাতার বিভিন্ন আদালতে ওনারা প্র্যাকটিস করতেন।
They used to practice in many court in Calcutta.
Mr. Bhattacharya, I am handing over you 3 to 7 some documents which are corresponding pages 3 to 7 of the judge's brief. Kindly tell my lord what are these documents about?
এগুলো হচ্ছে আমি দিল্লিতে যেতাম যখন, বা দিল্লি থেকে ফেরত আসতাম, তার অরিজিনাল রেলের টিকিট রিজার্ভেশন করা।
Is the railway ticket which I used to go to Delhi.
Which I purchased to proceed to Delhi.
কি বলবো? আনসারটা একবার কি আনসারটা দিবেন?
This is the railway ticket which I used to.
Which I purchased to proceed to Delhi.
Mr. Bhattacharya, from where have you obtained these tickets, train tickets?
আমি রিজার্ভেশন কাউন্টার থেকে কাটতাম।
I purchased this ticket from the railway reservation counter. Purchased this ticket from railway reservation counter.
Can you tell this court from which railway reservation counters you have purchased this ticket?
কখনো শিয়ালদা, কখনো হাওড়া স্টেশন। আচ্ছা,
Can you say from which railway reservation center you have purchased the ticket?
Sometime I used to buy in from Sialda and
হাওড়া স্টেশন।
sometime in Howrah. Howrah
এটা
station.
এইদিকে শুনতে পারে।
Sometime from Howrah station. Sometime I used to buy these tickets from Sialda station. And sometime from
Howrah.
Howrah station.
You can stop there. 3:45 other
It's
matter.
a fixed matter.
Next day,
Lordship,
I am fixing a date.
কটা আছে দিকে?
Lordship, this doc, I will, on the next day, I will tender it and mark as it.
নিবে যাও।
Counsel for the respective parties are present. Written witness number 1. Examination of the plaintiff witness number 1. Started. But due to paucity of time, examination could not be completed. Fix when it can be given. 24th July at 2 p.m.
Lordship, sorry,
24th July
24th of July
at 2 p.m.
Your Lordship, not any date before diary does, no problem.
If you want, I can give 2 dates. 24, 25.
20 is
24
completely
July.
taken. It's not Jishnu Chaudhary's diary.
There's
There's no room is
space
left.
on these pages.
He always makes fun of me. No space. You're completely vacant. It's not his diary. We have to ask for time. He says that you keep my diary and post your conference time.
No, Chaudhary has you have not been given the diary. He has given all the advocates of your this engagement.
I have not been blessed with his diary.
Mr. Chaudhary has circulated his diary
He's
to all
so
the
busy.
advocates.
Everybody has to take his diary and take.
That's why they are taking the dates from taking the dates from.
Your Lordship is correct. Grateful.
Yes, fixed matter. तो क्या करेगा?
Before your Lordship, Lord, I'm not against any.
जानिए.
Lord, before your Lordship takes up, Lord, this matter.
So you want to argue on
item
marriage?
number 53.
You want to argue on marriage?
Yes, Lord, kindly takes it up day after tomorrow, subject to your Lordship's convenience. Lord.
After tomorrow is very difficult. After vacation.
After.
My Lord, kindly fixes the time anytime after vacations.
You are also there.
Lord. Yes, he's also.
He's the main man, my Lord.
The man behind.
And not friend, not friend. Okay. When can be at 3:45? Any date is there? 3:45? No, after vacation. 20 June, 21st June. Give 20 June.
Fixes a time, Lord, subject
3:45.
3:45. I'm great.
You, 3:45.
Hey, it's card.
I am opposing an application for judgment upon admission. That's the most important factor in an eviction suit. Lord, please see the prayer. Decree and/or judgment upon admission made by the defendant in the present case. That's prayer A, page 12. It has to be on admission or not at all. Lord, what is the admission? Is the next issue. Admission, let's not kindly have a look at the petition. Till paragraph,
from paragraph 6.
Yes, but that's not, my lord, the admission. Please see paragraph 19.
19.
Paragraph 19.
Paragraph 19 of plaint.
Of the petition, my lord, I'm sorry.
Petition.
Of the petition. Paragraph 19 of the petition refers to a power of attorney dated 13th February 2012 issued by the defendant number 1.
Yes.
And that power of attorney, my lord, is annexed as Annexure G.
Yes.
Annexure G, my lord, is at page 104. In the next paragraph, my lord, paragraph 20. The said document being the power of attorney dated such and such disclosed by the defendant has a clear admission of the defendant that he, the managing director of the defendant number 1, is not able to look out the business and therefore they have given all power to Muhammad Ayub. That's the admission.
Correct.
That's the admission, nothing more. Then, my lord, the inferential contention is from the averments made in the power of attorney that the user and control of the tenanted premise has been parted with and deed of partnership has been drawn up
So you are not the control over the property, it's given to the third party.
So the admission is blood. We are on judgment order 12 rule 6.
Yes, judgment, admission.
Admission. His case in the petition is that the admission is that I am not able to look after the business because kindly see, my lord, the power of attorney, page 104.
Yes.
Partnership, and then at 106, partnership firm consisting of 2 partners, myself and Nuzhat.
I am not in position to look after the business of the aforesaid
Business of the firm personally in a proper way. I nominate, constitute, and appoint my known person, Mohammed Ayub,
Correct.
as my attorney. Why? To represent our firm to all rents and purposes in our outside India, etc. Demand, recover, receive, etc. Then blood 107 to acquire, sell, paragraph 4, dispose of, stock in trade, etc. etc. This is the, and then page 111, what he relies on, paragraph 17, to tender and pay monthly rent in respect of the premises for myself and on my behalf to the landlords. So, my lord, he says that this is proof of subletting. Let me, my lord, I'm also going to submit that even at a trial, this would not, my lord, work. Having regard to, my lord, the West Bengal Premises Tenancy Act. But here it's even more difficult for the petitioner because this is judgment upon admission. My lord, please have I'll quickly take your lordship through, my lord, the judgment upon admission cases. Admission has to be clear and explicit. 2000, volume 7, SCC, page 120.
2000,
volume 7,
SCC.
SCC 120. You know, this is the parent judgment. Uttam Singh Duggal. I'll just আর কিছু নেই তারপরে May I just read up and hand up, Lord? Before the trial judge, there was no paragraph 14.
Yes.
In fact, I'll read from paragraph 12. As to the object of Order 12, Rule 6, we need not say anything more than what the legislature itself has said when the said provision came to be amended. In the objects and reasons set out while amending the said rule, it is stated that where a claim is admitted, the court has jurisdiction to enter a judgment for the plaintiff and to pass a decree on admitted claim. I just wait. The paragraph 12. The paragraph 12 now towards the middle to pass a decree on admitted claim. The object of the rule is to enable the party to obtain a speedy judgment, at least to the extent of the relief to which, according to the admission of the defendant, the plaintiff is entitled. We should not unduly narrow down the meaning of this rule, as the object is to enable a party to obtain speedy judgment, where the other party has made a plain admission entitling the former to succeed. It should apply, and also where there is a clear admission of facts in the face of which it is impossible for the party making such admission to succeed. So, Milord, either on the basis of the statements in the power of attorney, my learned friend can succeed, or I would definitely fail. Now, Milord, see paragraph 14. But I'll try and make it short. Paragraph 16, in fact. Now this is admission on pleadings or otherwise, 15, 16 or otherwise. So, my lord, it can even travel beyond pleadings.
Yes.
So, my lord, it must be clear, it must be specific as paragraphs 12 and 14 say. And number 3, either my case should become hopeless or my learned friend's case should become unimpeachable. This is the scope. Now, my lord, please see what is subletting. My lord, I'll just indicate my main points. What is subletting? Subletting is transfer of right to exclusive possession to exclusion of all others. In this case, there is no proof of transfer of possession. There is no proof that I have left.
Yes.
That we are entitled to lead evidence to show that entire possession is with us. There's been no transfer. Because your lordship would remember, my lord, that in the next judgment, which is Karam Kapahi's case, Supreme Court says that I must have a right to explain away the admission also. It's not conclusive judgment. I can explain away the admission. So that right, my lord, that would be taken away in this case. Now, my lord, induction of a partner does not, second point, my lord, induction of a, firstly, there is no proof of transfer of possession. There is no admission of transfer of exclusive possession. Number 2, induction of a partner does not result in subletting. Number 3,
Yes.
there is nothing to show that I have left, that the existing partners, my lord, have relinquished control or possession, which must be exclusive.
Yes.
Then, my lord, on exclusivity of possession, alleged possession of the power of attorney and divestment of myself, I have some evidence to show it's wrong. Their allegation is wrong. I'm still there. And I'm entitled to lead evidence. That right cannot be taken away. Eviction suit, my lord, cannot be brought to an end on this hypothetical situation. Eviction suit, my lord, interlocutory decree in an eviction suit is possible if there's a clear admission. Yes, I have sublet to my learned friend, or I have parted with possession and she is exclusively under control. Short of that, this is all, my lord, very vaguely inferential. Section 106 cases, it may be possible. Otherwise, no. Now, my lord, let me show your lordship, my lord, what is subletting. 2005, 1 SCC, page 481. This is I'm sorry. The paragraph 16 of this judgment is relevant. Yeah, this I give copy now. The rent control case. Please, my lord, take paragraph 16. the term sublet is not defined in the Act. I think it was the Delhi Act, new or old. However, the definition of lease can be adopted mutatis mutandis for defining sublease. What is lease between the owner of the property and his tenant becomes a sublease when entered into between the tenant and tenant of the tenant, the latter being subtenant qua the owner landlord. A lease of immovable property as defined in section 105 of the Transfer of Property Act is a transfer of a right to enjoy such property made for a certain time for consideration of a price paid or promised. A transfer of a right to enjoy such property, please mark this word, to the exclusion of all others during the term of the lease is a sine qua non of a lease. A sublease would imply parting with by the tenant of the right to enjoy such property in favor of his subtenants. So there are two things. A, his right is to the exclusion of all others. And B is I relinquish my right and I don't retain anything for myself. Now, my lord, please see that this is all that I had to show. Now, my lord, please see the power of attorney. I'll be let keep at page 104. I'll keep coming back to it.
Yes.
Milord, page 106, Milord. Partnership firm, I'll read from the top of page 106. Consisting of two partners, Mansoor Ahmed, that's myself, and Mrs. Nuzhat, wife, by virtue of a deed of partnership under notarial certificate, such and that, carrying on business of tailoring and selling of suiting and shirting. And due to some personal jobs, I may, sorry, personal jobs, I many times live abroad. Many times, intermittently live abroad. English is quite wanting. And I am not in a position to look after the business of the aforesaid firm personally in a proper way. So I hereby nominate, consider, appoint my known person to do the following deeds. So I'm giving the attorney, my lord, right to represent the firm, contracts, documents, etc., trade business, to ask for demand, receive, collect money. Then my lord, page 107, to represent elsewhere, file proceedings, to acquire, sell or dispose of goods or stock in trade, to apply for renewal of licenses, prepare, sign, submit returns, etc. Suits, proceedings. Now, my lord, kindly, usual things. And then, my lord, paragraph 17. To tender, my lord, 17 at 111. To tender and pay monthly rent in respect of the said premises for myself and on my behalf to the landlords. Otherwise, go to the rent controller. There is nothing in this document which would show that. Now, today it must directly show, because this is admission, that I have handed over exclusive possession to the subtenant, and subtenant has possession exclusively to the exclusion of all others, and I have not retained any right in respect of that property. How is it possible to come to this conclusion from this document? Today we are on admission, we are not on inference.
What about para 19?
If it says, my lord, to enter into any agreement with the landlords as may be necessary, that doesn't mean that I have handed over possession to him. I give him a right on my behalf or in the name to or represent the firm. I am giving him authority to represent the firm. Am I giving him subletting his my lord possession? There's not a single sentence of possession in this power of attorney. My lord, my lord, read the judgment, my lord, and I'll read another one. Subletting has to do with possession.
Correct.
Next power ছিল আমাদের
I'll come with change of partnership. My learned friend correctly says you must deal with it. I said I will. But first things first, if you want a decree, when we do suits, my lord, in the
But in Parakan, kindly come to the page 106.
Yes.
I am not in a position to look after the business of the aforesaid firm.
Yes.
Personally and proper way. So I nominate, constitute, appoint so and so by faith, so and so as my attorney to do. So as per this admission, so he is not in possession.
No.
He's not running the
No.
business.
Wait. He says I'm not in a position to look after business personally in a proper way.
Correct.
That doesn't mean that's why, my lord, kindly, my lord, because I have 2 points to meet. Number one, I have the point of subletting. Number two, the legal point of then with this document and in the other, because once Ayub died, there were powers of attorney for his sons also. I have to show that with that change in the partnership firm, or if there is no change at all, whether it would amount to subletting or not. That's the second point. What is the impact on the partnership firm?
That is different thing with regard to the partnership.
That's a different matter. No, there's also another point there. I'll show. What used to happen is there are judgments which say, or my lord, arguments are made. Partnership firm is a tenant. You take in a whole lot of new partners and you retire. That amounts to subletting. There's an argument to that effect made. I'll deal with that argument. There are two arguments possible. Number one is argument of induction of new people, what impact it has. And number two is subletting. So I'm on subletting first. Will not kindly have a look at that judgment once more. 5-1 SC 2005-1 SCC 481.
Correct.
Milord, your lordship has it before your lordship. Milord, please come to paragraph 16.
Correct. Last 4 lines.
Yes.
A transfer is a right to enjoy such property, exclusion of the others.
Correct. During the term of the lease. Sublease would imply, please see this, sublease would imply parting with by the tenant of the right to enjoy such property in favor of his subtenant. It's a very forensic allegation. Subletting is a forensic allegation.
Correct.
Before the small causes court and city civil court, when suits are done, to prove subletting, you have to show tenant out, subtenant in exclusive possession. Now, my lord, this is inferential. This is inferential. I'm giving a power. Now, let's see the power of it. Your lordship is right. It kind of gives an impression that you've left.
Yes.
You're busy. You can't handle business. You've put in a power of attorney.
Correct.
But that, that it does not lead to the inescapable conclusion that there has been subletting insofar as the suit property is concerned. I'm letting somebody look after some aspects of my business. I'm not relinquishing my possession of the property. I remain as partners. Firm is the tenant. Firm remains. And please see the change of constitution. Will you kindly take the plaint at page 15. Paragraph 4 at page 25. This is the plain. Print starts at 23, page 25, para 4. Last 5 lines. Mansoor Ahmed, Nuzhat Ahmed, defendant numbers 1 and 2, had been carrying on business in the suit premises in the name and style of Limos. The said firm Limos was and still is an unregistered firm. Plaintiff landlord issued 2 separate rent bills in respect of Schedule A and B to defend numbers 1 and 2 in the name of Limos. So Limos is partnership firm. Partnership firm is the tenant.
Yes.
The form of the suit is also defective. Defendant numbers 1 and 2 in the name and style of Limos. Maybe they've done so because it's an unregistered firm, which is also incorrect. I will show it's a registered firm. On that ground, the plaintiff will go. Now, my lord, please see paragraph. I'm sorry, please see page 28, not paragraph, my lord, page 28. Right at the top.
Yes.
Has fourth line, has sublet or parted with the suit premises to some other person without the consent of the landlords, and thereby provision of 6(1)(a) was violated.
Yes.
Now, my lord, please see. You haven't even given particulars. Now, my lord, kindly see the written statement, paragraph 11, at page 46.
Yes.
My lord, page 46, originally paragraph 11. Originally, partnership firm Limos belonged to 2 partners, Rosario and Syed Sultan Ahmed. Milord, I must pause here for a moment. This is when their work was very good. After Milord Rosario has left, their Milord suits have also become very bad. I will lead evidence, Milord, on that. Now, Milord, this is the original Rosario and Syed Sultan Ahmed. Very famous shop. My father, father-in-law, both no more. Both used to go.
Famous tailor.
Now, Milord, kindly come to page 47. Since after death of the said partner Sultan Ahmed in the year 2000, his wife and sons, Famida Ahmed and Syed Mansoor Ahmed, entered into partnership business as partners with Rosario. In 2003, new partner Ashfaq Ahmed entered.
Where from you reading?
Milord, page 47.
2000.
Subpara 4.
Yes.
New partner. First Famida, then Ashfaq, then 3 partners, Milord, were Rosario, Ashfaq and Famida. Then Syed Mansoor took his wife Nuzhat, and this went on. It's been reconstructed. I'm sorry, Milord. Yes, the partnership has been reconstructed from time to time. Then, Milord, page 48, second paragraph. Then Ayub came in. Milord, page 48, paragraph 7. আমি কিছু ভালো করে চিনি আমি চিনতাম মরে গেছে তো yes, yes. Now, Milord, what has happened is property has changed hands. Now, Milord, they have taken over, they've purchased the property, they want to get rid of us. So the point I was trying to make is, Milord, from the beginning, partners have kept changing of Limos. Even now, that is the situation. There are existing partners Ayub was one of the partners. Lordship has seen Ayub was one of the partners. Other partners retained their rights. Partnership firm is tenant.
Correct.
Other partners retained their shares in the partnership firm.
But in the power of attorney, he has not stated that his share, whatever it is, he has given the full shop room to him.
Power of attorney is not for an immovable property.
Kindly come.
The PC 106. Power of attorney is to let him
No,
look up.
partnership firm consisting of
Yes.
two partners.
Yes.
Mansoor Ahmed, myself, and Nusrat. By
Correct.
virtue of data partnership under the notarial certificate carrying on the business tailoring.
So,
and selling of-
Milord,
So,
two partners
correct.
permit the third partner to look after their interests
He is the
of the partnership firm.
He is one of the partner.
Yes.
Acha, Muhammad Ayub is the one of the partners.
Yes, he's one of the partners. So, Milord, for partnership business to be carried out, often you need all partners to sign. Often you need concurrence of all partners.
Got your point. Good.
So two partners are letting the third. There's no relinquishment.
No.
Now, Milord, see the law once more, Milord. Your Lordship knows. Milord, 1986, Volume 3, SCC 62. Milord, I'll be very quick with the judgments now. Milord, that is the point which I wanted to make.
Yes. Which page?
Yes,
Paragraph?
Milord. 86, paragraph 5 and 6.
5 and 6. Yes.
In the first case, the fact was that a shop room was let out to a certain firm of 3 partners. Business of partnership was closed before November. Thereafter, a new firm consisting of an erstwhile partner and a stranger started doing business. Question arose whether in these circumstances it could be said that there was subletting. The contention that the old firm and the new firm were different legal entities and occupation amount subletting, then Milord, submission that entry of a stranger as a partner of the new firm indicated that there was subletting was also not accepted. Question, Milord, on the next page, 66, question what was necessary to be proved when subletting was alleged was then considered. And Milord, this is also important. He has to prove that there was subletting by his tenant. He does not prove this merely by showing that his tenant was one firm and premises in the occupation of another firm, as he sought to do in the present case. Mere possession by somebody other than the tenant would not necessarily prove that the premises has been sublet by the tenant to the person in possession. It is admitted that there is no evidence in this case to prove the fact of subletting. In this case in particular, premises continued in possession of one of the original tenants. It may be, as learned counsel for the appellant said, that the attention of the courts below had not been directed to the fact in issue, etc., etc. And Milord, next paragraph, paragraph 6, Milord, Justice Subba Rao's earlier judgment is referred to. It says, Milord, it is clear from the aforesaid decision there cannot be subletting unless the lessee parted with legal possession. In my case, what has happened? I am there. I am a partner. I have retained my partnership rights. And I am not here for some time, so I've given you a power of attorney to act in my behalf when I'm not there. I have not given you my legal rights. And from the inception, Milord, new partners have come in and gone out. An induction of partners is never subletting. That also this judgment, Milord, continues to say. And Lord, we filed a supplementary affidavit showing that even today, all licenses are in our name. Limos. I was knocking off the television. Lord, may I come back, my Lord, if your Lordship
Any
permit?
further?
5 minutes, my Lord.
What?
What I can do is, I can, day after tomorrow, my Lord, come and mention the matter, take 5 minutes and give my note.
Then they will give.
She is, my Lord, your Lord. When I get stuck with a tenancy matter, I go to her.
That
She's an expert on tenancy law.
I keep learning from my senior.
Actual expert on tenancy. Premises Tenancy Act. No one knows better.
No, that is something.
Good. Very good.
I keep learning from him.
Learning experience to work with her in a tenancy matter. And my record is very bad. Her senior was also a wonderful tenancy lawyer. And I lost the matter before Justice Showman Sen's bench. But subsequently now, in an appeal, I have succeeded on the same point. If I can mention the day after tomorrow, Willard, for 5 minutes, I'll just make a
They
note.
will also take time. Manutosh. কি হবে? अभी तो कुछ हुआ नहीं। After
There is no
vacation.
admission.
After vacation.
My lord, this matter is fixed as part-heard matter, but it's not indicating in the list, my lord, it's a part-heard matter.
This is part-heard matter. Very important.
21st what time? 21st June 3:45.
I'll come with my
But
notes.
anytime 45.
You do one thing, both the party come with the written notes. Oh,
Yes,
you have already
Notes is
submitted.
already filed, my lord. Both the parties written notes are already filed.
No, my lord, I'm going to recall my notes. That must be filed by, no, not by me. I will file a fresh note.
Counsel for the respective parties are present. Counsel for the defendant has argued the matter at length, but due to paucity of time, argument could not be completed. Fixed 21st June at 3:45 p.m. as part-heard matter.
Gratefully.